justice and equity. That's what it stands for. It's not against anybody in particular. Mazen Nnamdi Kanu has come to court today to make it clear to the court that he has told the judge that he has no constitutional power to try him. Ab initio, the court lacks jurisdiction. Even from the Supreme Court, they made a mess of this case by remitting the same case back to Federal High Court. That is called double jeopardy in law. You cannot try a man who has been discharged and still refer the same case back to Supreme Court, back to Federal High Court. What for? But if they had brought in new charges, perhaps we'll understand.
But how would you explain the outburst in court just a while ago?
It's a natural thing to happen because Omotosho is not willing to listen, is not willing to obey the Constitution, is not willing to obey the Supreme Court orders. So what is Mazen Nnamdi Kanu doing in court in the first place?
But you and I know that Justice Omotosho has given Nnamdi Kanu several periods to open his defense. And today he's opening his defense.
No, he did not. He came today for ruling. And you know, let me make this clear to you. By cross-examining those witnesses that came to court, he has opened his defense. So Mazen Nnamdi Kanu should be allowed to go for his final written address. And the very judge does not want to allow him to do that. In the interest of fairness, he should allow him to do so. He said he's proceeding to go on rule. That's what he said today.
But the judge said that in other proceedings that happened before, Nnamdi Kanu said the same thing through his former lawyers. And he's still saying the same thing. That is the ruling of the judge. But
Mazen Nnamdi has the final right for his written address. Is that correct?
But this I don't want to be confrontational, sir. Apologies. But this same issue has been raised in the past and it was dismissed.
And when you don't adhere to the issues at the point of law, what do you do? What do you do? What do you do? They phrase the issues the way they want to phrase it. If they are to go by the constitution of this country, Mazen Nnamdi Kanu would even be in jail in the first place. That you need to understand. I think you and I have followed this case from the beginning up until now. Tell me one single evidence to convict Mazen Nnamdi Kanu. Evidence based on hearsay. Nnamdi Kanu made a broadcast in London which was monitored in Nigeria. Specific place they cannot identify it. Then they moved from that charge and said he made broadcast somewhere around the world. Where is it in the world which was monitored in Nigeria? They couldn't establish that. Now, a few days ago, the prosecution came back and said, oh, you made a broadcast in Nigeria. Where is it made exactly? He must have to tell the court. But they are unable to provide all these informations because they don't have any. Also bear in mind that the witnesses they showcase in court, they are mercenaries. They are mercenaries. And that is why we have filed for perjury today at the magistrate court in which they are here. So for how long would this evil keep going? Go everywhere in Nigeria, people are dying. Terrorists are killing people. Did Mazen Nnamdi Kanu kill anyone? The answer is no. So what is he doing in detention? It's an act of evil. Attack against Mazen Nnamdi Kanu is attack against the Igbos and the innocent people of this country. Those who believe in fairness and equity should rise up now and not tomorrow. I think I can say thank you so much.
Thank you. You just heard from the brother of Nnamdi Kanu. That is the person of Emmanuel Kanu. He's quite angry at the situation, at the entire outburst, and he's saying that it is warranted that Nnamdi Kanu is a human being. And of course, you know that some of these cases Nnamdi Kanu is raising now has been raised in the past, and the judge is saying that this particular questions and particular observations, applications, and motion Nnamdi Kanu is raising in the court cannot be sustained because these same issues have been trashed in the past. I still have one lady who was in court who experienced the entire outburst of Nnamdi Kanu here, and she's willing to speak to us. Come over, ma. Good afternoon, ma.
Good afternoon.
What is your name?
My name is Lolo Nneka Chimeze, and I am the president of Igbo Women Assembly.
Well, what would you make of the entire outburst that happened inside the courtroom?
I mean, anybody in Mazen Nnamdi Kanu's shoes will have that outburst.
Well, you think it's right?
Of course he is. I mean, what else can he do? What else can he say? If he is not allowed to exercise his fundamental human right, what else? You try to protest in the best way or in any way you can. I mean, I've witnessed these proceedings on 2 occasions, and I am so disappointed. And in fact, Nigeria should arrive because I think we are at war with the judiciary. Not just Nnamdi Kanu's case. If you look at the judgments and counter judgments of the judiciary, I mean, it's alarming. It's destroying this country. Remember.
But let me hold you there. The judge is saying that some of these issues that Nnamdi Kanu is raising has been raised in the past and has been addressed. The judge is saying that Nnamdi Kanu was given ample time to open his defense, which he declined severally. That is the position of the judge. What do you make of this statement?
Now, the point is that not that he declined. He opened his defense by cross-examining the witnesses. But what he's saying is that he has nothing to defend because even the law at which they are trying him does not exist. that they are trying him on a repealed law. So there's nothing to defend there. Not that, I mean, in cases where he has to do something in terms of defending himself, like cross-examining the witnesses, he did. But when you now ask somebody to defend something that does not exist, he will tell you that there is nothing to defend there. I think that is the message Nnamdi Kanu is trying to pass. The point is that for the judiciary, they felt
All right, a break in transmission there from Abuja, where our correspondent Joshua Maraye is outside of a courtroom where Nnamdi Kanu is to learn his fate today. Let's not forget that Kanu's trial has been one of Nigeria's most talked about legal battles in recent years. He was first arrested in 2015 and charged with treasonable felony and terrorism, but the case has taken numerous turns since then. In 2017, Kanu fled the country while out on bail following a military operation at his residence during the time of Operation Python Dance in the southeast. And then in June 2021, he was arrested in Kenya under contentious and controversial circumstances that even necessitated an investigation on the Kenyan side of things, and he was brought back to Nigeria to a move which his legal team and IPOB, the Indigenous people of Biafra, described as an extraordinary rendition. Now, upon his return, the charges were expanded to 15 counts, including terrorism and incitement to violence. Now, his defense has repeatedly challenged the trial's legitimacy, and they argue that fundamental legal and procedural errors including possible violations of international extradition law and jurisdictional rules, undermine the prosecution's case. Now, we continue to follow this. It started this morning on Breakfast Central around 9 a.m. He began speaking, and he said that there is no judgment as he has filed his processes, and he says no judgments would hold. Then we also had the judges who started the hearing with appearances, and Kanu was saying that, or rather the judge, I beg your pardon, was calling for decorum in the courtroom, and a number of other things followed. And towards the end of it, right as Jasiri was starting, we saw Nnamdi Kanu being escorted out of the courts, visibly upset, raising his voice and saying a number of things. This trial has really captivated Nigeria for the past several years, and today seems to be D-Day.
D-Day.
Yeah.
I'm hoping that they'll come to some kind of to some kind of judgment. The judge will probably look at all the evidence before him and review everything and give a judgment. Whether the judgment would be taken as done is another thing, because I know that he's a very contentious person, and the matters before the court is a bit tricky. You know, matters of terrorism, and they're quite elevated charges. So we really, really need to make sure that we must make the judgment that we get, is very deep and very concise.
But there's no, in this case,
elaborately as they can.
In this case, it's damned, not him or the judge, but it's literally damned if they do, damned if they don't. There's really no judgment.
I don't want to be the judge.
Of course not. There's no judgment that's going to temper this situation. For some people, no judgment will ever be right, and for other people, no judgment will ever, not other people's, Jesus. Right. And for other people, no judgment will ever be right.
Right, and not to forget that Kanu's defense team as well completely left the job, especially when it came to the
opening his defense.
His defense. And there's been situations. He's always had outbursts since his own defense started. He wanted to lead his defense. He was supposed to have opening statements, but unfortunately, we crossed back live.
Yes, we're hearing that the judge is reading now. Let's head right back to the courtroom in Abuja.
1 sub 2B of the Terrorism Prevention Amendment Act 2013. Count 3, that you, Nnamdi Kanu, male adults of Afaraku, Ibeku, Umuohia North Local Government of Abia State, on dates between 2018 and 2021 within the jurisdiction of this honorable court, profess yourself to be a member and leader of indigenous people of Biafra, IPOB, a proscribed organization in Nigeria, and that you thereby committed an offense contrary to and punishable under Section 16 of the Terrorism Prevention Amendment Act 2013. Count 4, that you, Nnamdi Kanu, male adult of Afaranuku Ibeku, Umuohia North Local Government Area of Abia State, on date between 2018 and 2021, made a broadcast received and heard in Nigeria within the jurisdiction of this court in furtherance of an act of terrorism against the Federal Republic of Nigeria and the people of Nigeria, in which you incite members of the public in Nigeria to hunt and kill Nigerian security personnel, and that you thereby committed an offence punishable under Section 1(2)H of the Terrorism Prevention Amendment Act 2013, count 5. That you, Nnamdi Kanu, male adults of Afaranuku Ibeku, Umuohia North Local Government Area of Abia State, on date between 2018 and 2021, made a broadcast received and heard in Nigeria within the jurisdiction of this court in furtherance of an act of terrorism against the Federal Republic of Nigeria and people of Nigeria, in which you incite members of the public in Nigeria to hunt and kill family of Nigeria security personnel, and that you thereby committed an offence punishable under Section 1(2)H of the Terrorism Prevention Act 2013. Count 6. That you, Nnamdi Kanu, male adult of Afaranuku Ibeku in Umuohia North Local Government Area of Abia State, date between 2018 and 2021, made a broadcast received and heard in Nigeria within the jurisdiction of this court in furtherance of an act of terrorism against the Federal Republic of Nigeria and the people of Nigeria, in which you directed members of the indigenous people of Biafra, IPOB, a proscribed organization, to manufacture bombs, and you thereby committed an offence punishable under Section 1(2)F of the Terrorism Prevention Amendment Act 2013. Count 7. That you, Nnamdi Kanu, male adult of Afaranuku Ibeku in Umuohia North Local Government Area of Abia State, on date between the month of March and April 2015, imported into Nigeria and kept in Uguluzo in Ihiala Local Government Area of Anambra State, within the jurisdiction of this court, a radio transmitter known as Tram 50L concealed in a container of used household items, which you declare as used household item, and you thereby committed an offence contrary to Section 47(2)A of the Criminal Code, Cap C45, Laws of the Federation of Nigeria 2004. In discharging its body of proof, the prosecution called 5 witnesses as follows. 1. Mr. AAA as PW1, Mr. BBB as PW2, Mr. CCC as PW3, Mr. DDD as PW4, Mr. EEE as PW5. The prosecution also tendered the following, which were admitted in evidence by these courts. 1. A document titled Items Recovered from Nnamdi Kanu of Radio Biafra at Golden Oakley Hotel, located at number 42/44 Airport Road, Lagos, on the 15th day of October 2015, was admitted and marked as Exhibits PWA. 2. Two discs titled Interview with Nnamdi Kanu and a Certificate of Compliance filed on the 28th day of April 2025 were admitted and marked as Exhibit PWB and PWB2 respectively. 3. The statement of defendants dated 15th day of October 2015 was admitted and marked as Exhibit PWC. 4. a process titled A List of Items of Nnamdi Kanu filed on the 19th day of March 2024 was admitted and marked as Exhibit PWD. 5. 4 bags as identified by PW1, Mr. A, were admitted and marked as exhibits E bag A to E bag D respectively. 6. Items in exhibit E bag A as identified by PWA were admitted and marked as exhibit E bag A1 to E bag A13 respectively. 7. Items from exhibit E bag B were admitted and marked as E bag B1 to E bag B32 respectively. 8. 10 items from exhibit E bag C, exhibit E bag C1 to exhibit E bag C10 respectively. 9. Contents of exhibit E bag D were admitted and marked as exhibit E bag D1 to exhibit E bag D17 respectively. 10. A letter dated 10th day of June 2021 from the Attorney General of the Federation and Minister for Justice addressed to the Director General Department of State Service was admitted and same was marked as exhibit PWF. 11. The statement of the defendant Nnamdi Kanu dated 17th day of July 2021 was admitted as exhibit PWG. 12. A device to its flash drive, black and red in color, and a certificate of compliance were admitted and marked as exhibit PWH and PWH1 respectively. 13. A disc in respect to the statement of the defendant taken on the 17th July 2021 and certificate of compliance thereto were admitted and marked as exhibit PW1 and PWI and PWI1 respectively. 14. Federal Republic of Nigeria of Official Gazette number 99 in volume 104 dated 20th day of September 2017 titled Terrorism Prevention Order 2017 was admitted and marked as exhibit PWJ. A document to its medical report titled Late Ahmed Gulak, hospital number 013931 dated 18th July 2021 was admitted and marked as exhibit PWK. 16. A certified true copy of the judgment in HIN/FR/2021 between Nnamdi Kanu versus Federal Republic of Nigeria and 7 others delivered on the 19th day of January 2022 was admitted and marked as exhibit PWL. 17. A certified true copy of judgment in FAC/UM/CS/30/2022 delivered on 26 October 2022 between Nnamdi Kanu versus Federal Republic of Nigeria and 2 others was admitted and marked as exhibit PWF. 18. A certified true copy of the judgment in suit number E/2023 between Mazi Nnamdi Kanu applying for himself and on behalf of members of indigenous people of Biafra IPOB versus Federal Republic of Nigeria and 4 others delivered on the 26th day of October 2023 was admitted and marked as exhibit PWN. 19. A document titled Lagos State Judicial Panel of Inquiries on Restitution for Victims of SARS-related abuses and other matters was admitted and marked as exhibit PWO. 20. A faster flash drive with certificate of compliance were admitted and marked as PWP and PWP1 respectively. 21. A disc titled Interview with Sahara Reporter with Certificate of Compliance was admitted and marked as PWS. 22. The search warrant dated 28th day of October 2015 with search report was admitted and marked as PWT. 23. A disc mass radio transmitter extra with certificate of compliance was admitted and marked as PWU. 24. The statement of Benjamin Madugugu dated the 3rd day of November 2015 was admitted and marked as PWD. 25. A SanDisk flash drive with its attachments and also with certificate of compliance was admitted and marked as PWW. 26. Online printout of Vanguard newspaper and certificate of compliance was admitted and marked as PWS. 27. A container containing a transmitter was admitted and marked as PWY. 29. A certified true copy of report on request for professional assessment of radio transmitter dated 25th day of November 2015 was admitted and marked as PWA2. 30. Certified true copy of Vanguard newspaper of 3rd day of July 2021 from National Library was admitted and marked as PWP2. 31. The payment received with the revenue collection receipt from National Library of Nigeria receipt number 19128 of 7th June 2025 was admitted and marked as PWC2. 32. The report of assessment of the damage as a result of exercise was admitted and marked as PWD2. 33. Death reports and certificates of security officers was admitted and marked as PWD2A. 34. Certificate of compliance was admitted as PWD2B. PWY. The evidence of the witnesses. Mr. AAA is an officer of the Department of State Service. His schedule of duties includes arrest, investigation, and taking of statements of suspects. According to him, the defendant is the leader of the indigenous people of Biafra group. He stated that his first contact with the defendant was on the 14th day of October 2015, when he was detailed by his commander in the Lagos office to go to Essential Airport Hotel to arrest the defendant. PW1 stated that he went with some other officers, with one of them named Bolaji Adeyemo. On arrival at the hotel, they introduced themselves and informed the hotel workers that they were there to arrest the defendant. PW1 even showed the receptionist the photograph of the defendant, but he was told that the defendant was not in the hotel. He then asked for the guest manifest, but the name of the defendant was not on the manifest. So PW1 reverted to his commander, who then ordered that they conduct room-to-room search. In the process, they enlisted the cooperation of the manager of the hotel, who availed them of the master key of the rooms. Shortly after, Bolaji called PW1, who was downstairs with his director, informing him that he had found the defendant in room 303. On getting to the room, PW1 stated that he met a young lady who was later identified as Miriam Ibezi-Marco. He introduced himself to the defendant and informed them of the purpose of their visit. Thereafter, they proceeded to arrest the defendants, who initially resisted arrest. PW1 further stated that during the encounter, Olaji intervened to calm the situation after the defendants had booted in. Whereupon the defendants eventually agreed to follow them to the station. PW1 stated that the room looked like a broadcasting studio due to the broadcasting items mounted on the table, such as microphone, a tripod and airport, transmitter, mixer and cords. PW1 said they located the defendant at about 23 hours of the day. When they arrested him, they also arrested him with some of his baggage, which was listed in the sheet of papers which the defendant signed. He said the items recovered were about 70, and it took some time for him to complete the inventory. PW1 stated further that on the following day at about 9 a.m., he was instructed to take the statement of the defendant. So he took him to the interview room and recorded the statements from him, which was captured on video. PW1 stated that at the time he took the statement of the defendant, the allegation against him was that he was the founder and leader of an organization known as the Indigenous People of Biafra, IPOB, through which he allegedly agitated for the violent secession of Nigeria's southern eastern states, south states, and as well as 2 states from the north central region, namely Benue and Kogi. Also, that he founded Radio Biafra, through which he broadcast his intentions, inciting the general public, particularly his followers and those who are sympathetic to his cause, to violence to achieve the solution he was agitating for. PW1 then stated that he issued the defendant with his service statement form after administering the cautionary word onto the defendant, and then he proceeded to write down his statement. The defendant signed the statement and same was countersigned by me, PW1. PW1 stated further that the international passport of the defendant was recovered bedside docker. Also, that the defendant used the name of Owanekei Ezebigo to book the hotel accommodation, and that was the name in the manifest. PW1 stated that during the interview of the defendant, he admitted to the allegation against him that he is indeed the founder and leader of Indigenous People of Biafra Group, and that he operated Radio Biafra, which is not registered by the Nigeria Broadcasting Commission or any other government agency. In addition, the radio station broadcasts information across Nigeria and the world at large. Under cross-examination, PW1 stated that he was one of the officers who interviewed the defendant, and that during the interview, the defendant's lawyer was not present. PW1 said he took the statements of only the defendant, and that the items recovered from the defendant did not look offensive. Also, that they did not analyze the phone of the defendant as they thought it was immaterial at that time. He said he did not personally arrest and investigate any person who may have committed any crime on the instigation of the defendant. Furthermore, that he did not investigate the lady arrested with the defendant to see if she was aiding the defendant in terrorism activities. PW1 denied knowing if the defendant's name named any other person as a co-conspirator, or if any other person is standing trial on a related charge. PW1 said, from his knowledge, the defendant had the support of persons like Simon Ekpa in his agitation for secession. He said the defendant incited others to destroy public properties. PW1 stated that even though there have been killings in other states, such as Kaduna, Zamfara, as far as he could tell, those killings were not product of agitations for separation. He said he knows that IPOB was prescribed in 2017, but he does not have other details of the matter. PW1 stated that there are people who carried out the order of defendants, including sit-at-home order, in which people have been killed for disobeying the directive. He stated that he is not aware that a charge against the defendant for inciting persons to kill military officer was struck out by the court. Under re-examination, PW1 stated that the agitation of the defendant in this case is for a call for separation from the country for the southeastern, south-south, and some north-central states. PW1, Mr. BBB, is an officer of the Department of State Service. He stated that the defendant is a member and leader of prescribed terrorist group called IPOB, which means the indigenous people of Biafra. PW2 also stated that he was assigned to take the statement of the defendant on the 17th day of July 2021, and that the purpose for the statement was for him to answer to the allegation contained in the letter sent to them by the Honorable Attorney General of the Federation. PW2 stated that the defendant is also the founder of Eastern Security Network, which is the armed wing of IPOB, and that he also established and operates Radio Biafra illegally, which was not registered with the Nigerian Broadcasting Commission, that the defendant told him all this during their interactions. PW2 further stated that during this interview, he was with his director and 4 other officers, as well as the defendant and 2 of his lawyers, namely Mr. Alo Ejimako and Abila Topchak. That the defendant admitted that he made broadcasts inciting people to burn, kill, and collect weapons from police officers wherever they see them. That the defendant also made statements, written statements on the same day. He said the defendant admitted founding the Eastern Security Network, and that he admitted making broadcasts where he ordered his followers to ensure that whoever flouts the sit-at-home order, the attack, and they led to the death of many people, including destruction of properties. PW2 further stated that one of the unfortunate persons who lost his life includes Ahmed Gulak, the former senior special assistant to the President Goodluck Jonathan, who died on 30th May 2021, and also that the defendant made broadcast on the 20th day of October 2020 during the NSAS process, which led to the destruction of properties, including Lagos High Court building in Igoshere, as well as part of the Muritala Mohammed Airport. Further, that the defendant asked the employers to behead any military or police officers, and this led to the killing and beheading of a military couple in Olu, in Imo State. In addition, it was established that a retired judge, Honorable Justice Stanley Nnamdi, was also killed as a result of the defendant's broadcast. PW2 stated that the aim of the defendant was the creation of the Republic of Biafra by any means possible, including war. Under cross-examination, PW2 stated that the video statement of the defendant was a complete reflection of what transpired during the interview, even though the camera was focused on only the defendant and his counsel. He stated that he does not know if and how long the defendant was kept in solitary confinement prior to the statement being taken. He also said during the interview, the defendant did not tell him that he was frustrated or angry. PW2 said further that he is not aware of the content of the charge against the defendant to know if any person was instigated or incited by the defendant to commit any crime. He also stated that he did not know if at the time of the DSS received Exhibit PWF, the charges are already been pending against the defendant. PW2 stated that even though the governor of Southwest States formed the Amotekun group to tackle security in their region, he is not aware if the Attorney General of the Federation wrote to the DSS to investigate the activities which led to the formation of Amotekun. He stated that he never listened to Radio Biafra but only got reports from the DSS security platform, where people who are mandated to monitor sales put their reports. PW2 said he was not part of the team that arrested the defendant and he did not investigate the defendant's assertion that he was kidnapped from Kenya, as it was not part of what was related to him by his boss. PW2 explained that extradition is a process of bringing a person from another country to a country to start his trial. PW2 denied that an officer of DSS kidnapped the defendants in Kenya since they are restricted to only Nigeria. He said Nigeria is a signatory to the United Nations Charter and as well as the African Charter, and that many countries got their independence through agitation for self-government. He said there is no country today known as Biafra, even though the Nigerian Civil War was fought on the agitation of people of Southeast attempting to form their own country. He said he does not know if the defendant's home was attacked on the or that 28 persons were killed. PW2 stated that he visited some of the places that were destroyed as a result of the broadcast of the defendant, such as police station in Ebonyi State. Also, that he is not aware of the status of Sarara reporters and whether it is registered. He said the defendant confirmed that he ordered it at home in the southeast. PW2 confirmed that General T.Y. Danjuma, retired, has accused the Nigerian security forces of not being natural, of not being neutral. He said he is not aware that the Director General of DSS urged Nigerians to rise up and resist terrorism. He said he is aware that the NSIS movement was never classified as terrorist organization. He said the defendant was and remained a member of IPOB before and after it was prescribed by the court. Under the examination, PW2 stated that Amotekun is not the same as Eastern Security Network, as Amotekun is recognized by law passed by the Houses of Assembly in the Southwest States, while Eastern Security Network is not registered, not recognized by any law, so it is an illegal association. PW3 is Mr. EEE is an operative of the State Security Service and have been with the agency for 27 years. According to him, the defendant is the leader and founder of indigenous According to him, the defendant is the leader and founder of indigenous people of Biafra, a proscribed terrorist organization, and also served as the director and broadcaster of Radio Biafra, which was used to incite the public. He stated that his first contact with the defendant was on the 24th day of October 2015, when he was instructed to interview the defendant and to take a statement regarding the allegation about his activities in operating Radio Biafra and also the founder of IPOB. He stated that on the first day, he invited the defendant to the DSS interview room at the national headquarters, where he and 3 other officers interviewed the defendant, and also video recorded of the interview, which defendant consented to. He said the defendant did not reduce his statement in writing until 23rd day of October 2021 due to complaint of his being tired and needing to rest on the 24th day of October. He said the written statements were then signed by the defendant when he finished writing. PW3 in his further testimony stated that during the interview of 24th day of October 2021, the defendant was confronted with video recording of interview with Sahara reporter. In that video, defendant was resolute that there must be a change and the change will not come through peaceful means. PW4, Mr. DDD, also officers of the State Security Service and has been in service for 25 years. According to him, the defendant is the founder of IPOB, a terrorist organization calling for the secession of southern, southeastern, south, and states, and some parts of Benue and Kogi from the Federal Republic of Nigeria. PW4 stated that he got to know the defendant in October 2015 when he was arrested by officers of the DSS. He stated that allegations against the defendant include that he was agitating for the secession of Biafra and using Radio Biafra to incite members of IPOB against the Federal Republic of Nigeria. PW4 stated that further that on the 20th day of October 2015, through an intelligence, they discovered that the defendant smuggled a radio transmitter without declaring sale to the Nigerian Customs Service, that it was hidden from view using household equipment and was contained in a container. PW4 stated that it was kept in the custody of one Benjamin Madugugu in Anambra. PW4 said he got to know all this when he was handed a video recording when the defendant was seen in the company of Madugugu inspecting the radio transmitter and taking ownership and declaring it as a game changer, which Radio Biafra will be broadcast through. Following an instruction from his superior, PW4 obtained a search warrant and on the 28th day of October 2025 proceeded to the village where Benjamin Madugugu was and retrieved the radio transmitter. PW4 stated that when they opened the container, they found only the transmitter in it and asked Benjamin what happened to the other items, and he said the defendant came to inspect the. It's one individual named Chimeze who took the other items away, leaving only the transmitter in the container. He said Benjamin Madugugu wrote a statement on the 3rd day of November 2015 at the DSS headquarters, and he confirmed the result of the search. Benjamin Madugugu, when asked, did not produce any custom paper. Benjamin was initially arraigned along with the defendant until he jumped bail and the case was severed. He said, IPOB has made life difficult in Southeast due to the sit-at-home order of the defendant, as well as the violence unleashed by IPOB. Further, the Eastern Armed Security Network, which is the armed wing of IPOB, bears arms, engages in guerrilla warfare, where they attack security agencies such as the police and the Nigerian army. They also ensure compliance with the sit-at-home order. PW4 stated that in a particular broadcast of 30th day of May 2021, the defendant issued threats that anyone who defies his order of sit-at-home by opening their shop should be killed and the shop burnt. PW4 explained that Ahmed Gula, the former senior special assistant to the former president Goodluck Jonathan, was killed on the day declared to be a sit-at-home. that he tried to take another route to the airport in Owerri when he was shot by IPOB terrorists. PW4 said he was the first person at the scene and he found the lifeless body of Gulag on the road. He said that from the feedback he got from residents of Southeast, the sit-at-home order had depleted the economy and activities in Southeast and the people were living in apprehension for their safety. PW4 also said that he knew one Ikonzo, identified as one of the dreaded commanders of Eastern Security Network, which real name is Kanikayo Andy. He described Ikonzo as a ruthless commander who took direct orders from the defendant. PW4 further stated that Ikonzo was killed on the 24th day of April 2021 after masterminding attack in Olu, Imo State, during which he mobilized Eastern Security Network members and other adherents of IPOB to attack the correctional centers and facilitate the escape of numerous inmates who were in lawful custody. He also attacked the police headquarters and a lot of police stations or police officers were killed. However, he was involved in a shootout with security operatives after a manhunt was declared on him. The shootout led to his death. PW4 stated further that on the following day, 24th day of April 2021, the defendant made a broadcast in which he declared that Ikonzo would be buried specially in the manner of the Oba of Benin, meaning that he would be buried with human heads. Consequently, the defendant's order is meant to procure human head for the burial of Ikonzo. The order was carried out by one of his junior commanders named Emery Uzoma Benjamin, known as Oye Ami. That when Oye Ami was arrested, he wrote in his statement that the defendant ordered him to get the head, but he was only able to secure 30 human heads. At the scene of where the transmitter was kept in the premises of the Department of State Service, PW4 continued his evidence when he stated that the container containing the transmitter was recovered from the premises of one Benjamin Madibu, wherein the defendant had smuggled in the radio transmitter into the country. The container also had some household items in it, which were later removed. Upon the matter being adjourned back to the court, PW4 confirmed that Benjamin Madibu indeed made a statement before the DSS. During the statement taking, he had his lawyer, one Vincent Obeta, present with him. PW4 also stated that upon retrieving the radio transmitter, they brought the defendant and Benjamin Madibu together and confronted the defendant with the evidence. He stated that the defendant accepted ownership of the container and that the radio transmitter. He also exonerated Benjamin Madibu by stating that the items were only kept out. Benjamin Madibu to confirm and come and inspect the transmitter, which they duly came and wrote a report of the findings. The conclusion from the report as read by PW4 is that the station known as Radio Biafra was not licensed by the Broadcasting Corporation of Nigeria. Neither does he have any permit to operate in Nigeria. That for an organization to bring in a radio transmitter, it must apply for permission from the regulator, who is in turn right to the security agencies such as DSS and the National Security Advisor for clearance before the regulator issue a license to import the transmitter into Nigeria. That in this case, no such license permission was obtained by the defendant before importing this transmitter. PW4 referred to a newspaper story where the defendant had ordered an attack on prison in Imo. The defendant had ordered members of IPOB to kill security operatives. Also, that investigation revealed that the defendant having ordered members of IPOB to bury the cause in special way by using about 2,000 human heads. His men were only able to get 30 human heads. Efforts were made to arrest these IPOB members in Odu, in a village bordering Anambra Valley. They met some members of IPOB with human heads hanging from a wire mesh, and they also saw some of them eating human flesh, which they claimed was for spiritual fortification. They also saw as well where they dumped victims and beheaded bodies into. PW4 stated that he was part of the operation which comprised the DSS and the Nigerian. He also stated that the defendant has never denied making those state broadcasts and was even proud of making them. PW4 also stated that record shows that shows that between 170 and 200 security agents of the federal government were killed by IPOB and Eastern Security Network all over Nigeria. He knows some of these murdered agents, which includes his driver, one Chinemere Ereke, and their tactical leader who were killed in Umuma local government area of Imo State. PW4 stated that the defendant was in the habit of making inciting statements ordering his men to carry out attacks on security agents as well as political figures such as Uzodinma, the governor of Imo State. He stated that their mode of operation is that they move in group in Siena and other confiscated vehicles, and from there they launch attack on security operatives. They also set up checkpoints vehicle in good working condition. The group also engaged in activities aimed at terrorizing their community. That this group is so brazen that they even write to traditional rulers informing them of their intention to attack them. They attack even in broad daylight, kill people, burn down palaces and properties. PW4 continued his evidence by stating that the IPOB group are even more brazen in their attack on police stations like the one at Njamba local government area of Imo State. That they raided the station, killed everyone there, and turned it to their base. Similarly, the police station in Umoma, in Oru East local government area of Imo State, was sacked in the same way, and that the group even attacked a police headquarters where they shuttled away arms and ammunition from the armory and burned down the place. He stated that on the 2021, the defendant had ordered a seat at home in southeast, but the late Ahmad Gulad was unfortunately caught in the storm as he was trying to catch flight out of Owerri that day. PW4 said he was the first to get to the scene of that attack where he found the disease in the pool of his lot. He was informed by the additional police officer in the area that the disease was in a taxi heading for the airport when the IPOB and Eastern Security Network armed combatants identified him as one of their checkpoints and opened fire on him. The driver of the taxi identified himself as an Igbo man, but the disease, even though he claimed he was an Igbo man, could not speak the language, and having observed a prayer mark on his forehead, his attacker shot him. The body was later moved and conveyed in a plane to Abuja on the directive of the former secretary to the government of the Federation, Boss Mustafa. PW4 stated that between 2019 and 2022, he was in charge of security enforcement in Imo, and he witnessed firsthand the activities of the defendant and his men. PW4 stated that the defendant is the leader of indigenous people of Biafra, IPOB, as well as the founder and operator of Radio Biafra. He testified that the defendant used the said radio platform to incite members of the public to hate persons of other ethnic nationalities. PW4 further stated that through his broadcast, the defendant directed members of IPOB to attack and kill security operatives and to destroy infrastructures and symbols associated with federal government as part of his agitation for the establishment of the Republic of Biafra under cross-examination. PW4 stated that he did not sign any of the investigation reports and also that the transmitter came in the country through the Tinkan port in Lagos. He said he did not find out the date the transmitter came into the country as sail was smuggled into the country and that it was not part of his schedule to find out this. That there are no records to show it came in through Lagos, save for the statement of the defendant that he came through the Lagos port. This also stated that IPOB was formed outside Nigeria and that Radio Biafra was operated outside Nigeria but broadcast within the territory of Nigeria as it was an online platform. He further stated that the defendant was arrested in Lagos with his broadcasting equipment. He said it is not the duty of the DSS to find out if the Radio Biafra was registered in London. PW4 stated that he and one of the officers were sent to Ugulu to recover the transmitter that they reported to the DSS headquarters in Orca, and from there they proceeded to where the container was located using coordinates on video showing the containers. They testified that the container contained one other items including 2 pump action guns, one of which was found in the bedroom of Benjamin Madugulu, that he said Madugulu is facing a charge of illegal possession of weapon before Inyako jail. He also stated that even though the defendant stated that he does not like violence and crime and that churches and other places of worship should not be attacked, his broadcast of 20th, 24th, 25th October 2020 clearly incited people to kill others. That the main cross of the defendant broadcast is the killing of Fulani herdsmen by raiding the forest of Southeast with AK-47 killing the innocent. He said he is not aware of any Fulani herdsmen being in Southeast state. PW4 admitted that Goodluck conducted the primary election that led to the emergence of the governor of Imo State, Hope Uzodinma, and that satisfaction over the declaration of Hope Uzodinma was still questioned. He stated further that even though Goodluck was with 2 other persons in the car, he was the only one trying to not kill Igbo person who violates the sit-at-home order. He admitted that the defendant said IPOB will compensate the person which lorry of onions was hijacked, but he does not know if the promise was fulfilled. PW4 stated that it was the police who investigated the killing of Ahmed Goodluck. He said during the sit-at-home, everywhere including farm are usually deserted and it is dangerous for anyone to be outside. PW4 also stated that the Nigerian Broadcasting Commission monitors the frequencies of every radio station in Nigeria and they were able to monitor the frequency of Radio Biafra. He stated that the DSS could not arrest Abubakar Shekau due to him trying an explosive device to himself at the point of arrest. He said during his time in Southeast, he did not arrest any native doctor making sham for kidnappers. Also, that the checkpoints of police and the army are still functional in the Southeast today. PW5, Mr. EEE is an officer of his department. other investigators to travel around countries that occurred between 2020 and 2021 relating to the EndSARS movement. He stated that the assignments included obtaining records from head of security agencies in the states visited, particularly the states in the southeast and FCT, obtaining reports of deaths and death certificates of security personnel who died, as well as public properties destroyed as a result of EndSARS protests and riots. PW5, while referring to Exhibit PWD2A, stated that 8 policemen were killed in Abia, 16 in Enugu, 16 in Imo, 17 in Akwa Ibom, 16 in Cross River. There were 6 police officers killed in Lagos, 9 in Rivers, bringing a total of 128 policemen killed. With respect to military officers, a total of 37 killed. The DSS had 10 casualties. A total of 167 police stations were destroyed during the protest. Then 9 INEC facilities were damaged and destroyed. Under cross-examination, PW5 stated that he only investigated the deaths of security operatives who were killed during the EndSARS protest following the incitement by the defendant who instigated protesters to kill security agents and even taught them how to manufacture Molotov cocktail to use in the process. He further said it is on record that defendants urged protesters to destroy public buildings in places like Lagos. He said he does not know if one of the protesters, Aisha Yusuf, is sympathetic to Biafra or is a member of IPOB. He said he is aware that the police brutality was one of the causes of the EndSARS protest and that the defendants urged people to take up arms against the government. PW5 said there is no part of the report stating the activities of IPOB or ESN. He also said all protocols relating to taking of photographs were duly observed. He said from pages 669 of the report. There are some visible dates on the photograph. PW1 stated that there is no portion of the document signed by himself as secretary of the Presidential Ad Hoc Committee of the committee that investigated the aftermath of the EndSARS protest and the chairman of the committee. However, he stated that he certified the document and that the document was not certified after the proceedings of 12th day of June 2025. The defendants had filed a notice of preliminary objection dated and filed 16th October 2025 seeking for the following reliefs. 1. A declaration that they continue the prosecution of defendants under the Repealed Terrorism Prevention Amendment Act 2013 upon a prescription order obtained ex parte and without fair hearing violates Section 1, Sub 2, Section 36, 1 to 12 and 42 of the Constitution of the Federal Republic of Nigeria and Article 7 and 28 of the African Charter and is therefore null and void. 2. That the declaration that the Federal High Court ex parte order describing IPOB obtained without notice or hearing and while Justice Peter Iyako's official ruling that IPOB is not an unlawful society remains in force is unconstitutional, unlawful, and cannot ground criminality. 3. An order striking out or permanently staying counts 1 to 8, counts 15 of the amended charge dated 14th January 2022 for being barred by double jeopardy, having the same factual ingredient as count 6 to 14, earlier struck out by the Federal High Court on the 8th day of April 2022. 4. An order declaring that the defendants extraordinary rendition from Kenya without extradition proceedings on due process violates Section 36(1) and 9 of the Constitution, the Extradition Act, Cap E25, Law of Federation of Nigeria 2004, and Article 12 and 13 of the African Charter, thereby robbing the court of the jurisdiction. 5. And order nullifying all proceedings conducted in breach of the defendant's right to adequate facilities for defense, confidential communications with counsel, and for fair hearing, particularly dropping, seizure of legal materials, and denial of unmonitored access. The notice of preliminary objection as 43 paragraph affidavit deposed to by Ms. Nnamdi Kanu is sending to the defendant. The affidavit has been exhibit and written address. In his written address, the defendant submitted inter alia that the Court of Appeal in CA/ABJ/C/625/2022 has ruled in his favor on the 13th day of October 2022, holding that his extraordinary rendition has divested the trial court from continuing his trial. Thus, the instant trial is unlawful and in disobedience of the order of the appellate court. The defendant relied on the case of Okafor versus AG to proceedings that the provision under which he is charged to sustain these proceedings. He also submitted that his extraordinary he urged the court to quash the he also argued the of jurisdiction as the subject matter of this charge is subject to oppose the preliminary objection. In written address filed on 30th day of October 2025, the defendant substantially repeated the submissions in the notice of preliminary objection regarding the repeat law, extraordinary renditions, and denial of fair hearing. He therefore ordered the charge against him. The court formulates the following issue for determination. After going through the evidence, the address of defendants deemed to be final written address and that of the prosecution, the court formulates this issue. 1. Whether the defendant was denied of this case. Repeat law and inoperative. Establish the charge on reasonable doubt. Defendant has challenged the judicial competence. He premised his objection on the legality of the extraordinary rendition from Kenya in 2021, upon which he was brought back to Nigeria to face trial. He also raised an objection to the denial of his right to fair hearing, and that the charge was premised on repeat law, and thus the charge ought to be. This court will painstakingly consider this jurisdictional issue before going to the substantive issue if need be. To the extent of power and authority exercised by court in particular matter. Issue which determines whether to knowledge. Can it local Lord NIMR under citations of law? Equally, see the Adegboyega Awomolo and other citations also supplied in this regard. On the one, with respect to the alleged denial of right to fair hearing of the defendant, the tenet of fair hearing is to the effect that both sides in the Latin margin or the that a party can not be a judge or that a party cannot be a judge in his own court, as expressed in margin Judes in Kasaswa. Fair hearing is enshrined in Section 37 of the Republic of Nigeria and is civil rights and obligations, including any questions or determination by or against any government or authority. A person shall be entitled to a fair hearing within a reasonable time by a court or other tribunal established by law and constituted in such manner as to secure its independence and impartiality. Also see the case of MFA versus Inoga citation supply, where it was held, and I quote, fair hearing within the meaning of Section 36 of the Constitution of the Federal Republic of Nigeria 1999 means a trial or hearing conducted according to all legal rules formulated to ensure that justice is done to the parties. It requires the observance of two pillars of the rules of natural justice, namely, or the Otaran patent and the mode in Kasaswa. Simply means that no judge should decide over a matter in which he has personal interest or involvement. Also, my noble lord, late Nikki Toby, DSC of blessed memory in INEC and Musa citation supply, held and initiated on the principle of fair hearing. The defendant claimed that he was denied his right to fair hearing by the court, foreclosing him in the entry of his defense. As the risk of repeating myself, I will repeat my ruling of 7th November 2025, wherein I recounted the history of this case and proceeded to foreclose the defendant. This matter was filed in 2015, and due to the delay as a result of appeals and other issues, same was assigned to this court in March 2025. Prior to this, in 2017, the defendant was alleged to have jumped bail and escaped from Nigeria, and for about 4 years, the defendant was not in Nigeria within the territory of Nigeria, which caused a stop to his trial due to his absence. In 2021, he was brought back to Nigeria to face his trial. However, the defendant became unruly and caused serious delay in the trial before my learned brother, James. The issue got to a head that the defendant began asking my learned brother to recuse herself from the trial on the basis of being biased towards him. The judge recused herself, and the matter was assigned to this court in March 2025 for trial. Upon assumption of jurisdiction, having in mind that this matter has stayed for 10 years and the interest of justice, I granted a selected hearing. As a result of the selected hearing, I created morning and afternoon session in this court so as to accommodate this trial. The prosecution opened its case. In total, the prosecution called 5 witnesses and tendered several exhibits. The court ensured that the prosecution was kept on its toe during the presentation of this case, and same was closed on the 19th day of June 2025. It is worthy to observe that during the time when the prosecution was calling its witnesses, several adjournments were at the instance of the defendant. For instance, on the 29th day of April 2025, the defendant sought for an adjournment for cross-examination of PW1. Also, on the 2nd day of May 2025, the defendant's counsel also sought for adjournment for continued cross-examination of PW1. Likewise, on the 18th day of May 2025, the defendant's counsel applied for adjournment. In addition, on the 14th day of May 2025, the defendant applied for an adjournment also on the 21st day of May 2025. Defendants applied for an adjournment as part of the options opened or as part of options after the close of the case for the prosecution. The defense opted for the option of filing no case submission, which this court duly had after adoption of written addresses. Ruling was delivered on the 26th day of September 2025, wherein the no case submission was overruled. The issue of extraordinary rendition, validity of the charge, all were incorporated in the no case submission. After going through the no case submission, the court overruled same, and the defendant was called upon to enter his defense. In the ruling delivered on the 26th day of September 2025, the court emphasized and laid importance to the issue of fair hearing, as contained in Section 36 of the Constitution, that the defendant shall be given opportunity to defend the charge he is facing. Upon this, the defendant was called upon to do so. The court in that ruling also pointed out the need for evidence to be given on oath, to give evidence on oath to challenge the evidence of the prosecution. In that no case submission ruling, the court mentioned the importance of the defendant to give evidence on oath because this is a criminal matter. It is not civil, where the standard of proof is unbalanced of probability. It is a criminal matter which the standard required under Section 135 of the Evidence Act 2011 is beyond reasonable doubt. It's worthy to note that extraordinary rendition is a quasi-criminal issue in a criminal case, and evidence on oath must be given, and the opposing side must be given opportunity to cross-examine on that quasi-criminal issue in accordance with Section 135 of the Evidence Act 2011. Also see the case of the behaviour versus unruly citation supply, where the Supreme Court held that where any allegation of crime or quasi-criminal are made in any matter, even in a civil matter, affidavit evidence will be insufficient and only oral evidence will be entertained due to the standard of proof being standard required in criminal matter, which is beyond reasonable doubt. These defendants have the duty to prove the allegation of extraordinary rendition in this criminal matter beyond reasonable doubt. The defendant has not called anybody to testify on oath in respect of extraordinary rendition, which would enable the other side to cross-examine such witness. The failure of the defendant to give evidence on oath on extraordinary rendition has made the allegation bare. It is simple and assertion without proof. The court was constrained to deliver the no case submission ruling earlier, as during the vacation of this court, the defendant has filed an application that he moved to a private ward in the National Hospital Abuja as the facility of the Department of State Security Service were not adequate to take care of his health. The court had quickly rushed back due to the importance of health of the defendant. The court ordered the president of Nigeria Medical Association to constitute a panel of experts to carry out tests on the defendant to ascertain his health status and whether he is fit to stand trial. The need to ascertain his fitness to stand trial was based on the antecedents of causing delay in this trial. The court was suspicious whether the issue of medical reports based at that stage was preemptive of the ruling and laying foundation for unusual delay, which has been the trend since 2015. Based on this, the court added that the medical panel ascertained whether the defendant is fit to stand trial. It is actually a mystery to this court that a defendant who is standing trial would delay his own trial, while shouting that he is being denied his right to fair hearing. Usually, it is the prosecution that delays a trial as his life is not on the line. But in this case, the reverse was the case. The order of the court to ascertain his fitness was strategic to nip in the bud any attempt by him to further delay his trial. On the 16th day of October 2025, the court ruled on the medical report issued by the panel set up by the president of Nigerian Medical Association and determined that the defendant is indeed fit to stand his trial after no opposition from the defendant and the prosecution as regards the reports. The court had carefully observed the defendant during the entire trial and the spirited nature of the defendant. His unruly attitude and his agility in defending himself shows without that he is indeed fit to stand trial. Thus, corroborating the conclusion reached in the report by the panel set up by the president of Medical Association, even without the medical reports, the fitness of the defendant is clear to any reasonable person who observed him in court. His claim of being low on potassium or other nutrients as stated in his supporting affidavit to his application for transfer to National Hospital are not such that render him incapacitated from understanding the proceeding in this trial. He is healthy, fit, and abreast of all the happening in the trial, and demonstrated full understanding and fitness after taking over his defense himself from his counsel. I therefore hold without doubt that the defendant is fit to stand his trial. The court then proceeded to give the defendant 6 consecutive days to open and close his defense. Counsel to the defendant, Chief Kanu had prayed the court to allow the private consultation between the defendant and his counsel in preparation for his defense. Despite the fact that there was no evidence before the court of the DSS dropping on the conversation of the defendant and his counsel, the court graciously asked the defendant and his counsel to use the courtroom for their pre-trial meeting, since they felt more comfortable in the court. The development meant that the court had to clear the courtroom, and it meant that the court could not conduct hearing in the morning of 22nd day of October 2025, just to accommodate the defendant and his counsel. The court then adjourned the hearing for 24, 27, 28, and 29 and 30th October 2025 for the defendant to open and close his defense. On the 23rd of October 2025, the learned seat representing defendants including Kanu Agabi SAN, Onyechipe Adu SAN, Bolokoro SAN announced to the court that they wished to withdraw their appearance as defendant has indicated that he wanted to defend himself. Defendant confirmed the development and informed the court that he wished to represent himself as a party. Upon exercising his right to defend himself, the defendant came on the next date, and his excuse was that he was not given his case file by his departing counsel. This was no doubt another cause of a delay on his part. The following day, the defendant appeared for himself and began challenging the jurisdiction of the court, arguing that there was no charge against him and that the medical report certified him fit was alleged doctor. The court patiently explained to him that some of these issues he is raising have been treated in no case submission, and some of other issues could be raised during the final address. The court then, who are experts in criminal litigation due to the seriousness of the charge against him, the court also offered to secure the service of counsel from the legal aids or a private legal practitioner willing to take the matter pro bono, which were all rejected by the defendant. The court continued to appeal to him, and even on the death here. As a point, the defendant informed the court that he wanted to call about 28 persons as witnesses, some of which witness summons. The court graciously witness summons. However, the defendant abandoned these said witnesses and through the case file, and he found that there was no law providing for the offences he is being charged with, that he could not defend a charge not found on a law. By this time, the defendant has still not opened his defense. Neither was there any seriousness on his part to put it in effect, because in discharging his duty to do justice, calmly and patiently advised the defendant to be cautious of the path he tended to take, as it was tantamount to resting his case on the part of the prosecution, which means that he admits the fact, evidence against him, but believes that it is insufficient to secure conviction against him. This court has been extremely patient and lenient with the defendant. He is only entitled to be given opportunity to defend himself as part of his right to fair hearing. Failure to use that opportunity granted by this court will be entirely his fault. He cannot complain thereafter of fair hearing. The right of a defendant to defend himself herself is a fundamental right, provided under Section 36 of the Constitution of the Federal Republic of Nigeria as amended. Such rights cannot be taken from a defendant except where a defendant to open his rights. The court informing him that it was minded to extend the date if he opened the defense on the 7th of November 2027. The court on the 27th of October 2027 made an order that the defendant come on the next day to put in his defense or file his final written address, or any written address filed by him will be deemed as his final written address in this suit. Pursuant to this order of the court, on the 27th of October 2025, the defendant filed a motion on notice / comprehensive written address on notice on address on non-existence of a cognizable child and the unconstitutionality of continuing of trial filed 30th of October 2025, and same will be deemed to be his final written address. That address is deemed as ordered by this court to be his final written address. The address as a comprehensive written address cannot be overemphasized. The word comprehensive, as used in that written address by the defendant, means, according to the online version of the Oxford Dictionary, is, and I quote, including, dealing with all, nearly all elements or aspects of something, unquote. The defendant in the motion on notice and comprehensive written address prayed for relief, including for the court to discharge him, which is a typical prayer in final written address in criminal matter. No doubt, the defendant clearly knew what he was doing by opting for final written address in form of motion / comprehensive written address in compliance with the order of this court made on the 27th day of October 2025. This will therefore be treated as the final written address of the defendant, and same have been treated and considered in the entirety. The defendant had also filed a notice of preliminary objection on the 16th day of October 2025. These two should be considered in the interest of justice, as the court having ordered that all preliminary objections will be determined in the judgments. Also, the preliminary objection filed on the 16th October 2025 is also considered thoroughly in these judgments. Another aspect of denial of fair hearing raised by the defendant is that he was misled into taking his plea in the charge. When the charge was read to when the charge was to be read to him, the court asked if he understood English. He responded that he did. When count 1 was read to him, he at first stated that he did not understand. The court ordered the registrar of the court to read the counts to him. He understood and took his plea. For the avoidance of doubt, I will reproduce part of the proceedings of 24th day of March 2025 when the plea of defender was taken. Registrar Nnamdi Kanu, do you understand and speak English language? Defendant, I do. Yes. Registrar, listening to the charge against you. Count 1. Registrar, after reading, do you understand count 1 I read to you? Defendant, I don't. Court, take it again. Count 1. Registrar, after it, do you understand count 1 I read to you? Defendant, I do. Yes. Registrar, are you guilty or not guilty? Defendant, not guilty. Count 2. Defendant, do you understand count 2 I read to you? Defendant, I do. Registrar asks, are you guilty or not? Defendant reacted, I'm not guilty. Count 3. Registrar read to him and asked him, defendant, do you understand count 3 I read to you? Defendant, I do. Registrar asked him, are you guilty or not? Defendant responded, I'm not guilty. Count 4. Registrar read and asked him, do you understand count 4 I read to you? Defendant responded, I do. Registrar asked him, are you guilty or not guilty? Defendant responded, not guilty. Count 5. Registrar read and asked him, do you understand count 5 I read to you? Defendant responded, I do. Registrar, are you guilty or not? Defendant responded, not guilty. Count 8, now count 6. Registrar read and defendant, do you understand count 6 I read to you? Defendant said, I do. Registrar, are you guilty or not? The defendant responded, not guilty. Count 15, original 15, now count 7. Registrar read and said, defendant, do you understand count 7 I read to you? Defendant responded, I do. Registrar asked him, are you guilty or not? Defendant responded, not guilty. The defendant clearly understands English language, being an educated man. On that day, he had his counsel, including senior advocates such as Kanu Agagi, SN, representing him on that day. The court complied with the procedure of taking the plea of the defendants in accordance with section 2712 and 3 of the Administration of Criminal Justice Act 2015, which provide us 1. The defendant to be tried on a charge or an information shall be brought before the court unfettered unless the court says court otherwise to order, and the charge and information shall be read over and explained to him to the satisfaction of the court by the registrar or other officer of the court. B. Called upon to plead instantly unless where the person is entitled to service of the information he objects to the non-service, and where the court finds that he has not been duly served. 3. The court shall record the fact that he is satisfied that the defendant understands the charge or information read over to him and explained to him in the language he understands, and shall record the plea of the defendant to the charge or information as nearly as possible in words used by him. Looking at the above statutory provisions of Administration of Criminal Justice Act, the procedure adopted by this court, the defendant cannot turn round to claim he was misled to take plea after the prosecution has closed his case. It is nothing but the usual habitual flaw of the defendant to cause delay and make the matter to start with de novo. This court will not allow matter to be on his court list ad infinitum. On the issue of denial of adequate facilities, the defendant claimed that he was not allowed to consult with his legal representation in confidence at DSS, as the DSS officers were dropping on their conversations. The defendant is facing criminal trial and is entitled to the right to adequate time and facility in preparation for his defense. He enjoys the constitutional right to fair hearing, and in consequence to this right, has the right to adequate facilities as his defense. Section 36 6B of the Constitution of the Federal Republic of Nigeria 1999 as amended, provide every person, I quote, every person charged with criminal offence shall be entitled to be given adequate time and facility for the preparation of his defence. See the position of the Supreme Court in respect of this provision as initiated in Igwe and the state citation supplies. As part of the package of rights available to a person facing criminal charges, he is entitled to all the facilities and enough to time for purpose of preparing his defence. This ties in with the right to presumption of innocence under Section 36(5) of the Constitution of the Federal Republic of Nigeria 1999 as amended, which stipulates that until a person is declared guilty by a court of law, he is presumed to be innocent. The provision was the subject of interpretation by the Supreme Court, particularly by my noble Lord Akat ASC in Okoye and COP, citation supplied, where my Lord held, and I quote, the moment an accused person is facing a charge, his personal liberty is at stake, and before that liberty is taken away, he must be afforded every opportunity to defend himself. Once he becomes aware that he has a charge hanging upon his neck for an infraction of the law and makes a request either orally or in writing for any facilities to prepare his defence, the court must accede to his request and the prosecution has to comply. The facilities that must be afforded the accused person are the resources, anything which will aid the accused person in preparation of his defence to the crime for which he is charged. This, no doubt, includes the statements of the witnesses interviewed by the police in the course of the investigation, which might have absolved the accused of any blame or which may assist the accused to support such favourable witness that the prosecution counsel may not want to put forward to testify on oath. See case of Nweke and the state citation supply. The defendant did not provide any credible evidence as to this allegation of airdropping. The court, however, in order to do justice to him and suspecting that he was looking for another way to delay this trial, allowed him to consult with his lawyer on the 22nd day of October 2025 in the courtroom. Thus, the court had to vacate the courtroom for him, his lawyer to use. Despite this magnanimity by the court, the defendant did not make use of this opportunity. On the following day, the counsel withdrew his appearance. The defendant decided to defend himself, making the opportunity given to him to use the courtroom to be useless and of no purpose. Despite the fact that he is not a legal practitioner, he began using some of his counsel who he had earlier disengaged to act as legal consultants to him. The court even kindly ordered the DSS to allow these consultants have free access to him. This is in compliance with Section 36 of the Constitution of the Federal Republic of Nigeria, which provides for access to legal practitioners. Most of these legal consultants were always present in court. There is nothing to show that he was denied adequate facilities to prepare for his defence. He had enough time to prepare. Had been represented by senior advocates such as Nnamdi SN, Onyeshi Ike Azu SN, Emeka Ispa SN, Paul Inokoro SN, how to not get SN among others before they were suddenly disengaged. And his defendant decided to represent himself, which this court suspected was also to cause another delay in the hearing of this matter. His allegation holds no water in the light of the facts and circumstances in this case. Consequently, this issue is resolved against the defendant. On the issue of extraordinary rendition, there are instances where a person commits offence against a country while residing in another country or flees the country soon after committing the same crime. In such instances, the country against which the offence is committed will request the country in which the suspect is residing to release him to it. The process is known in law as extradition. Extradition therefore refers to a legal process in which a state renders a person accused of committing a crime to the state against which the crime was committed, known as requesting nation. The Supreme Court in AG of Federation versus Kanu citation supply subsequently explained the concept of extradition as follows. Extradition is a cooperative legal process of one state called the surrendering state or authority which renders an individual to another state called the requesting state for prosecution or for punishment for crime committed within the requesting country jurisdiction. Extradition process is usually spelled out in bilateral or multilateral extradition treaties or agreements. Extradition becomes necessary when a criminal polity flees from one country to another to avoid facing trial or punishment. Persons who may be extradited include those who have been tried and convicted but escape custody by fleeing the country and thus convicted in absentia. A trial in which the accused person is not physically present. Extradition is distinguished from other modes of forceful removing undesirable person from the country, such as exile, expulsion, deportation. Extradition procedure are usually determined by the terms of the treaties between individual countries or by multilateral agreements between group of countries, such as the Commonwealth countries or the countries of the European Union. The receiving government then refer to its law. Its treaties specify obligations to the requesting nation and decide whether or not to extradite the person named in the warrant. Treaties signed in recent decades tend to take a dual criminality approach, classifying an extraditable offense that are punishable in both jurisdictions. Other extradition treaties, by contrast, tend to list covered offenses. Unquote. Usually, the requesting and surrendering nation have a treaty or agreement which allows for such transfer. Nigeria, for instance, is signatory to regional agreements like the ECOWAS Convention on Extradition and other multilateral schemes such as the London Scheme for Extradition, which within the Commonwealth. The London Scheme for Extradition within the Commonwealth enables Nigeria to request and surrender property to member nations of the Commonwealth. On the other hand, extraordinary rendition is an extrajudicial measure to forcefully bring suspect or defendant to the country against which an offence is committed. These extraordinary measures may include adoption. The Supreme Court of Nigeria alluded to this in the case of Federal Republic of Nigeria versus Nnamdi Kanu in SC/CR/13C1/2022, where my noble Lord arguing DSC held, and I quote, generally abduction or kidnap or any form of illegal removal of an accused from the territory of a state to another to face criminal trial or for a reason is prohibited by law. Extraordinary rendition or any other transfer without due process is unlawful. There is no doubt that the illegality in the process of bringing the respondent to Nigeria for the criminal case brought by the appellant against him in Nigeria, the attendant massive violation of his rights, render his prosecution by the appellant unfair and oppressive. While extraordinary rendition measures may, unquote, while extraordinary rendition measure may seem illegal on the face of it, the way and manner in which the attendance of a defendant is secured does not dictate his trial. In the United States of America, this is is known as Kelfibri doctrines. This doctrine developed through the case law, notable cases of Kel versus Illinois, 119 U.S. 436 1886, and the case of Freebly versus Collins, 342 U.S. 519 1952, where a messenger forcefully kidnapped the defendant from Peru and brought him back to the United States, even though he had been sent to Peru with a valid warrant and instructions to obtain the defendant with the cooperation of the local authority. Addressing Kel's due process challenge, the Supreme Court of the United States held that, and I quote, "Such forceful adoption is not sufficient reason why the party should not answer when brought within the jurisdiction of the court, which has the right to try him for such an offence, and presents no valid objection to his trial in such case." In Freebly v. Collins, 342 U.S. 519 1952, it was a case where the defendant was tried and convicted in the state of Michigan after being adopted by Michigan authorities from Chicago, Illinois. Applying its decision in care, the Supreme Court upheld the conviction of the conviction over challenges based on due process and federal kidnapping law. The essence of Kel's Freebly doctrine is that even though the act of rendition is illegal, a trial court may assert jurisdiction over the person regardless of the legality of the adoption under international law. In recent times, the Supreme Court relied on Kel's Freebly doctrines in United States versus Alvarez Machines in 504 U.S. 65 1992. Alvarez Mission, a Mexican citizen, was adopted and brought to the United States at the direction of the Drug Enforcement Administration. The Supreme Court of the United States held that despite his forceful adoption from Mexico by United States officials, it did not affect the validity of his trial in the United States. As said earlier, the issue of extraordinary rendition is quite a criminal issue, which must be proved beyond reasonable doubt in accordance with Section 135 of the Evidence Act 2011. The law in Nigeria is strict that even a civil matter, once a criminal element is introduced, it must be proved beyond reasonable doubt. For instance, where an allegation of forgery is introduced in a civil proceeding, the standard of proof is proved beyond reasonable doubt. See the case of Minister of Equity versus Violence Consultancies Services Limited and another, citation supply, where the Court of Appeal held, and I quote, "Every forgery involves an alteration of documents, but not every alteration of documents amounts to forgery. Forgery involves alteration with a fraudulent intent. In fact, an incident of forgery must be specifically pleaded and proved even in civil matters, as in this case, beyond reasonable doubt. The appellant in this appeal has made allegation of forgery, but failed to prove so. In the case of forgery, both the original document and the fake must be produced in court for examination. The appellant failed to produce any document in proof of these forged documents. Allegation of such forgery in any civil matters is criminal in nature. Therefore, proof is beyond reasonable doubt. See also the case of Muni versus Federal Republic of Nigeria, among other authorities. The evidence in proving an unlawful extraordinary rendition must be oral evidence obtained, which allows the adverse party to cross-examine the defendant on his oral evidence. The defendant only sought an affidavit to the fact that the affidavit evidence is best used in civil proceedings, where the standard of proof is on balance of probability. The affidavit filed by the defendant is grossly insufficient to establish if indeed he was extraordinarily arrested or he was illegally brought to Nigeria. The gap in evidence will therefore mean that no evidence was led regarding the extraordinary rendition. Assuming, without considering, that there was evidence regarding the extraordinary rendition, the court will consider the effect of the extraordinary rendition on the validity of the trial of the defendant. The defendant, in his written address, has argued strenuously that the way he was brought back from Kenya was illegal and thus initiates his trial before this court. He relied heavily on the decision of the Court of Appeal in Federal Republic of Nigeria versus Kanu, in appeal number CA/ABJ/CR/625/2022, delivered on the 13th day of October 2022 on the issue. The court held, and I quote, "The consequence of this session, I hold that the respondent is prohibited from being detained, tried, or otherwise dealt with in Nigeria for or in respect of any offence allegedly committed by him before his extraordinary rendition to Nigeria. The lower court thus has no jurisdiction. I further hope to try the appellant on counts 1, 2, 3, 4, 5, 8, and 15, which were rendered, which were retained by it, being charges allegedly committed by the appellant proud of his extraordinary rendition. In addition, by the forceful adoption and extraordinary rendition of the appellant from Kenya to the country on the 27th day of June 2021, in violation of international and state law, the lower court or indeed any court in the country is divested of jurisdiction to entertain charges against the appellant, and I so hold, unquote. When this issue came up before the Supreme Court, the Apex Court, in Federal Republic of Nigeria versus Kanu, in SC/CR/1361/2022, delivered on the 15th day of December 2023, the Apex Court held per ML Gaba JSA, and I quote, I quote my noble Lord M.L. Gaba JSC, I agree with the learned counsel for the appellant that the procedure used in bringing or producing the respondent before the trial court for the trial of the offences in the counts of the charge in questions in respect of which he was validly arraigned did not affect or even go to the statutory jurisdiction of that court to proceed with that trial. The procedure, mode, manner by which the respondent was produced before the court is in before the trial court is in law extraneous to the statutory jurisdiction vested or conferred on the trial court to try or adjudicate over the offences in question, particularly after the valid arraignment of the respondent and his plea thereto. The procedure used in producing the respondent to face his trial after the arraignment and plea to the offences and after jumping the bail granted to him by the trial court cannot reasonably be said to deprive or rob that court of the requisite statutory jurisdiction to adjudicate over or try the offences in question. In the above premises, the lower court, which is with the respect due to it, took its eye off the ball when it filed off the statutory jurisdiction vested or conferred on the trial court to subject it to procedural law dealing with the procedure for the arrest, extradition, or rendition of runaway fugitive offender to and from the foreign country. The provision of Extradition Act Cap E25, Law Federation of Nigeria 2004, articles and parts of the UDHR 1964 and pronouncement of...
All right, what you're seeing is live visuals from the court proceedings for the alleged terrorism charges leveled against the IPOB leader, Nnamdi Kanu. This is one of the most contested terrorism charges and legal battle of recent time. And of course, we have Joshua Imirai, who is on standby and will be giving us more updates on the court premises. Joshua, can you hear me? All right, Joshua, what is the atmosphere like outside of the court while the proceeding is going on? Thanks for staying with us. Now we go back to the courthouse in the FCT regarding the judgment that is now being read out on the case of the IPOB leader, Nnamdi Kanu, based on several allegations that have been leveled against him since 2017.
After this, which even though NATO is there, NATO is there, we say that we are ready to die, and everyone that comes to kill us will die also. Because things will start happening in the next 14 days. In the next 2 weeks, the slaughter will begin to happen. You see those CNN that have refused to come to Biafra. We come by force to see what is happening. We will make sure that every Nigerian soldier on Biafran soil will die. God is my witness. I will lead this burial myself. Unquote. Around 55 minutes mark to the estimates. He said, and I quote, I want the United Government to understand that we are ready to die than be slaves, unquote. At about 1 hour mark, he said, and I quote, Israel was named Palestinians by the Romans because they were too stubborn. Go and ask how they did it. They bombed them, the Romans, away. Not these roadside bombs. Every road leading to Biafra will be manned, landmark. Everything that is Nigeria, whether it is police, army, will blow till the kingdom come. Very neat and simple. Very neat and simple, unquote. The defendant also stated in that same broadcast, and I quote, we are asking for our freedom, and they are listening. But when we start doing what we want, the whole world will start begging us, and then I will come out from wherever I am and tell them that it's too late. Throw away your phones. The men incommunicado, as we are in the state of war. It will not kill you to do away with your foes. All people should go into the bush and stop the advance of this army, or else they will kill you. Unquote. These words spoken by the defendants in those broadcasts were not mere words, as they bear every traces of threats to harm people, including international representatives representing their nation in Nigeria. The said broadcasts were several in numbers, and defendants kept repeating his rhetorics that people will die if Biafra is not prepared. The defendant planned to commit the terrorist act did not only manifest in his broadcast, but was shown in a meeting he had with other Igbo people in the United States. At a World Congress, Igbo Congress meeting held at the 4 Points Hotel in Los Angeles, in the United States of America, as contained in Exhibit PWW. The defendant, while speaking to the audience, stated, and I quote, we must not miss this golden opportunity we are bound to suffer in this time to come. You must come out to support what we are doing. We need guns and we need bullets. I know we love life so much. Without it, Hausa will overrun us. They have succeeded in imposing oppression on us. They are coming. Boko Haram is coming in Igbo land. A female participant stood up to ask the defendant of his objective as well as one need for weapons. The defendant responded, and I quote, "We now know that the best way to defend ourselves is to be armed because Boko Haram is everywhere in Nigeria. So we need guns and bullets, and those of you in America will give it to us. Also on the 22nd day of this month, something will happen called the blood moon. Most of you don't know that just before the Civil War, there was blood moon. There was blood moon in 67, and it only happens once in a while because after this year, we will be free no matter what happens. If we don't get Biafra, everyone will live to die. We are not joking. His intention was quite clear. He believed only in violence as the solution to the creation of Biafra as a nation. And at the said World Igbo Congress, most of the participants were quite alarmed by the as his plans, and so they kept asking if he had considered the option of peaceful dialogue, to which the defendant was adamant that only violence could lead to the achievement of his aim. These threats of violence are nothing but terrorist acts, which was duly carried out by his followers as will be seen later in this judgment. The defendant knew what he was doing while making these violent statements. He obviously had an objective which one the face of it is political. That is secession of the state of Southeast, South and some middle belt states from the Federal Republic of Nigeria to form Biafra. The defendant was also bent on achieving his objective with the use of violence, and he didn't mind if his own people die in that process. As one of the crucial elements in establishing crime, the intention and the knowledge with which defendants carried out the acts can be expressed by him. If not so expressed, can be deduced from his conduct or activities or other connected circumstances. See Berede and Federal Republic of Nigeria. Evidence led by the prosecution, particularly the broadcast contained in Exhibit P acts preparation and importance of terrorist acts. The defendants had the opportunity to explain but failed and deliberately refused that opportunity. Thus, he did not place any evidence before this court to explain the context of the said broadcast or any reason which may be exculpatory in his favor. Having failed and deliberately refused to enter defense or give explanation, the court will rely on the uncontroverted evidence of the prosecution. This court therefore holds that the prosecution has established count one of the charge beyond reasonable doubt. Consequently, the defendant is hereby convicted in respect of count one. With respect to count two of the charge, the defendant was charged with making a broadcast received and heard in Nigeria with intent to intimidate the population, issue deadly threats that anyone who flouts a sit-at-home order to write his will, as a result of which banks, schools, markets, shopping malls, fuel stations domiciled in the eastern states of Nigeria were not open for businesses. Citizens and vehicular movements in the eastern states of Nigeria were grounded. This offense is also punishable under Section 1(2)(b) of the Terrorism Prevention Act. The ingredients are similar as contained in count 1, except that the prosecution must establish that the defendant indeed issued a threat to anyone who flouted his sit-at-home order in the southeastern state of Nigeria. The evidence as led by the prosecution shows that the defendant issued a sit-at-home order wherein he threatened the residents of the southeast states from going out. He further threatened that any church, markets, schools, banks or shops which opened will be destroyed. This was the purpose of his broadcast of 30th day of May 2021, where he stated that he had an announcement to make of the entire Southeast. He stated exactly at 9 minutes 10 seconds in the broadcast contained in Exhibit PWW DOS, and I quote, "Tomorrow being the 31st day of May, there is complete lockdown, no church, no markets, and nobody should be seen outside tomorrow. I do not want violence. I do not want anybody to resort to violence. I condemn it completely and totally. We do not want to spill the blood of the innocent. Therefore, I am urging restraint across board. I am urging our people to honor the memory of people who died. There will be no school, no church, markets, banks, car on the roads. There will be complete shutdown. If you want to be alive, do not come out tomorrow." What I'm saying is that do not come out tomorrow. If you value your life, there will be complete shutdown of Biafra land tomorrow. Any community that allows people to pass tomorrow will be in trouble. Anybody in any car or lorry except in ambulance will be in trouble. I know some people are very foolish, trying to open their shop around 12. If you open that very shop, we will burn you inside it. Especially Enugu, Umuahia, Abakaliki people. You are very stupid. Tomorrow we will show you, unquote. This statement at first sounded peaceful and even seemed as if he was only persuading people to honor the memory of some people. However, issuing threats to those who might want to obey his order, that might not want to obey his order. The people of the Southeast are Nigerians, and I take the share notice substantially are Christians who go to church, and merchants that are into trade, and their children who were threatened against going to church, their places of business and schools. This cause wonders. If this can be said to be agitation for self-agitations, unequivocally, I say no. The people of the southeast of Nigeria are entitled to their right to personal liberty, freedom of movement under Section 35 and Section 41 of the Constitution of the Federal Republic of Nigeria 1999 as amended. The said section provides, and I quote, "Every person shall be entitled to his personal liberty, and no person shall be deprived of such liberty, save in the following cases and in accordance with the procedure permitted by law. A. In execution of the sentence and order of court in respect of criminal offence of which he has been found guilty. B. By reason of his failure to comply with the order of court and in order to secure the fulfillment of any obligation imposed upon him by law. C. For the purpose of bringing him before a court in execution of order of court for upon reasonable suspicion of him who has not attained the age of 18 years for the purpose of his education or welfare. E. In the case of persons suffering from infectious or contagious disease, person of unsound mind, person addicted to drugs or alcohol, backgrounds for those people or purpose of those care or treatment or protection of community. F, for the purpose of preventing the unlawful entry of any person to Nigeria or of affecting the expulsion, extradition, or unlawful removal from Nigeria of any person or the taking of proceedings relating thereto. Provided that a person who is charged with an offence and who has been detained in lawful custody awaiting trial shall not continue to be kept in such detention for a period longer than the maximum period of imprisonment prescribed for him. Section 41 provides, every citizen is entitled to move freely throughout Nigeria, to reside in any part thereof, and no citizen of Nigeria shall be expelled from Nigeria or refuse entry thereby, or exit therefrom. They are also entitled, unquote, they are also entitled to their right to freedom of religion as expressed under Section 38 of the Constitution of the Federal Republic of Nigeria. The right to personal liberty, movement, religion are complementary of each other. Code jealously guides these rights, and they are basic rights which belong to them as inhuman beings. These rights are so fundamental. Kindly see, my Lord Agaku JCA has initiated on this in Okafor versus Lagos State Government and another citation supply. The people of the Southeast cannot be ordered to sit at home by a person, especially for someone who is not a legally recognized official of the federal government or an official of any of the states. The only person entitled to restrict movement of persons within Nigeria is the President of the Federal Republic of Nigeria under emergency power under Section 305 of the Constitution of the Federal Republic of Nigeria 1999 as amended. The President can order for a curfew area where there is a crisis or natural disaster. The defendant is not the President of the Federal Republic of Nigeria, thus lacks any power to so declare a seat at home in any part of the country. The defendant arrogated to himself power to he lacks, and with the threat of violence, order the residents of the southeastern states to stay at home or face the consequences of their disobedience. This is an unconstitutional act which is subversive and amounts to nothing more than a terrorist act. It is also a notorious fact that the people of Southeast have been subjected to sit-at-home threats on Mondays for years now. PW4, who stated that he was stationed in the Southeast, especially in Imo State for some years, gave evidence that Monday sit-at-home is a usual occurrence wherein the town are deserted, even the farmlands. PW4 also gave evidence on the death of one Ahmad Goodluck, a former aide to the former President Goodluck Jonathan, that the said Ahmed Goodluck had been killed by airport, meant in portion to the order of defendants. Ahmad Goodluck was trying to catch a flight out of Owerri on the 30th day of May 2021 when he ran into a checkpoint by IPOB and was shot dead. PW4 stated that he was one of those who got to the scene first. It must be noted that 30th of but notwithstanding, it leads to the death of a person. In the medical report from the Nigerian Police Medical Services, Owerri, the report is dated 18th July 2021 and it states, to whom you concern, medical report. Late Ahmed Goodluck Ahmed, hospital number. The victim allegedly shot dead by hoodlums suspected to be IPOB/ECN members on 30th October 2021 at about 7 hours along Airport Road, Owerri. Picture of lifeless man seen, body of deceased buried, information The above medical reports, duly signed by the medical practitioner, clearly states the immediate cause of the death of sent to the defendant as leader of IPOB and ECL. The action of the defendant cannot be excused under any circumstances. The action of a thief at home without any constitutional power, especially the accompanied by the threat, is a terrorist act. The defendant did not present any evidence to rebut this case, the case of the prosecution. Consequently, he admits the evidence as presented by the prosecution. The prosecution has successfully proved count 2 beyond reasonable doubt. Consequently, the defendant is hereby convicted of count 2. With respect to count 3, the defendant is charged with professing to be a member and leader of indigenous people of Biafra IPOB, a proscribed organization in which thereby committing an offense contrary to and punishable under Section 16 of the Terrorism Prevention Act 2013. Section 16 of the Terrorism and Prevention Amendment Act provides, and I quote, any person who is a member or professes to be a member of terrorist group commits an offense and is liable on conviction to imprisonment for a time not less than 21 years. The ingredients of the offense from the above provide provisions are: 1. The defendant must be a person. The defendant must be a member or professes to be a member of a terrorist group. 3. The terrorist group must have been proscribed as at the time the defendant claimed or professes membership of such group. As earlier established, defendant is a human being. There is no doubt about that. With respect to second ingredients, the prosecution has led evidence showing that the defendant was not just a member, but he was the leader of a terrorist organization known as Indigenous People of Biafra. Indeed, in the broadcast of 16th May 2021, as contained in the PWW, the defendant, in the beginning of the clip, stated this, and I quote, "My name is Nnamdi Kanu. I am the leader of Indigenous People of Biafra and director of Radio Biafra, Biafra Television. I will remain a loyal servant of the people," unquote. He further stated around 51 minutes mark into the video. If God is on our side, which I know He is, the army of Nigeria will die in Biafra land. Everybody will die. I will be the one leading it. By God's grace, everything called Nigeria will perish in Biafra land. The world must be prepared for what is to come, unquote. In several other broadcasts, the defendant admitted being the leader of indigenous people so far before this court, showing that the defendant is not member, and in fact leader of the same group. The defendant from the evidence before this court also possessed power to order the coordinator of IPOB in a broadcast dated 11th May 2021 in Exhibit PWW. The defendant, while commenting on the meeting of Southern Governor Ed in Asaba, stated around 35 minutes to the residents, white plate, and I quote, "Concerning the lockdown announced yesterday, I urge all people of Biafra and all those in Biafra land to disobey the lockdown order given by the Geological Republic of Nigeria. The reason is because they want to use the dead of the night to move their fighters into our forest. Because we have defeated their foot soldiers, we must resist this stupid lockdown, and it will not hold in Biafra. I am calling on all the coordinator, deputy coordinator of ECN, ESN, and IPOB not to sleep in their houses today, but to look for somewhere else to stay. Because now we are in the trenches. Now you will know what is freedom fighting for. It is not comfortable. It is not rosy. Do not sleep at home. Do not sleep at home. Change your phone and even your phone itself. The defendant no doubt belongs to the group and belongs to the professing to be a member. He is a leader of the group with the influence of commanding the coordinators of the group. Not only IPOB, but even Eastern Security Network, which is the armed wing of IPOB. In a broadcast of 12th December 2020, the defendant made an announcement in inaugurating the military group known as Eastern Security Network, which is the armed wing of the indigenous people of Biafra. He stated, and I quote, "We have cowards, spineless idiots as governors. They have given over our land to the Janjaweed to occupy in perpetuity. This very generation, this very IPOB will not tolerate it. Not now, not tomorrow, not forever. We will rather all perish and die than to allow our land to be taken over by the Janjaweed. This is a warning to all the governors who are conspiring due to one political conspiration to give our land to infidel and blood-sucking demons from this time. It cannot happen, not under our watch. We have been told that some of these invaders come from Gambia, Mali, from Niger Republic and some from Chad, according to Governor of Katsina State, Erifai. Therefore, we are setting up the Eastern Security Network to combat the excesses of these vagabonds, criminals from crossing the terrain along the same line as Amoteku, the one set up by Metiala. What we are launching before the world today is Eastern Security Network, not a Biafra army, and we will let the world know when the army is to march. But for our present purposes, we are setting it up to defend our land. Biafra against Maronda from the Sharif and the Islamic incursion led by terrorists, to be precise. In the coming days, you shall see them in their uniform, performing the critical issue of providing security for our land, unquote. His defendants, who was really being agitated, continued in the broadcast by stating, "No governor in the southeast and south-south have been able to form a security outfit. Therefore, IPOB must defend our land to the very last lot. We shall not stop, not now, not tomorrow, not forever, until our land is get rid of message of this Fulani terrorists." In the third video broadcast, there was a side video of the man of the Eastern Security Network dressed in black with black Eastern Security Network. This is therefore no doubt that the prosecution has established the second ingredient beyond reasonable doubt. With respect to the third ingredient, the evidence before this court shows that IPOB is a proscribed group. I take judicial notice of Section 3 under Section 122 of the Evidence Act of the order made by my learned brother Nyako J in suit number FAC/ABJ/CS/A71/2017 between Attorney General of the Federation versus indigenous people of Biafra, today dated 20th September 2017, wherein the activities of indigenous people of Biafra were prescribed. The said order iterized into PWJ, which is the Federal Republic of Nigeria Official Gazette number 99 in volume 104, dated 20th September 2017, titled Terrorism Prevention Order number Terrorism Prevention Order of 2017. The Gazette reads, and I quote, notice is hereby given that by the order of Federal High Court in suit number FAC/ABK/CS/871/2017 dated 20th September 2017, as per the schedule to this notice, the activities of indigenous people of Biafra are declared to be terrorist and illegal in any part of the country, Nigeria, especially in the southeast, south-south region of Nigeria, as prescribed pursuant to Section 2 of the Terrorism Prevention Act 2011 as amended. 2. Consequently, the general public is hereby warned that any person or group of persons participating in any manner whatever in any form of activities involving or concerning the collective intention or otherwise of the said group will be violating the provision of the Terrorism Prevention Act 2011 as amended and liable to prosecution. The import of the above is that beginning from the commencement date of 20th September 2017, any person claiming to be a member of IPOB commits a terrorist act. The defendant, by his broadcast of 11th May 2021, 12th December 2020, professed to be a member of Prosecuting. Thus, he is in breach of Section 16(1) of the Terrorism Prevention Amendment Act 2013. Consequently, he is hereby convicted of count 3.
As compared.
Or count 4 and 5, which are closely related. The defendant is charged with inciting members of the public in Nigeria to hurt and kill Nigeria security personnel and their family members, thereby committing offence under Section 1, Sub 2H of the Terrorism Prevention Amendment Act 2013. The section provides who knowingly outside Nigeria, direct or indirectly, willingly incites, promises, or induces any other person by any means whatsoever to commit the act of terrorism or any of the offences referred to in the act, commits an offence under the act and is liable to a conviction to maximum of death sentence. The ingredients of the offence which the prosecution must establish beyond reasonable doubt are: 1. The defendant must be person of body corporate. 2. The defendant must have directly or indirectly incite, promise, or induce other person by any means whatsoever to commit the terrorism act. 3. The defendant must have directly or indirectly incited, promised, or induced other person by any means whatsoever to commit the terrorist act legally or knowingly. The defendants have been established to be a human being by the prosecution. But the second ingredient is important to understand what incitement means. According to the Supreme Court's per IPOB DSC of blessed memory, in CASA and the state citation supply, hold and I quote, an encouragement here means an act of making someone to feel brave or confident enough to do something by giving active approval in support of the crime. Incitement also have the element of encouragement. By incitement, the person is provoked by a strong passion or feeling to commit an offence. The word set is a word of quite a number of synonyms. The two words set on connotes the resemblance of causing to attack or chase, like one may be, say, the fisherman prepare the bait to set on a fish. It also has the element of antagonism. And instigation, the act of instigating, means something happened by the actions or conduct of a person who is the starter by the act of instigation, the co-accused is prepared or gingered to commit an offense, unquote. Likewise, the online Oxford Dictionary defines incitement as follows: the action of provoking unlawful behaviour, urging someone to behave unlawfully, unquote. The Cambridge Dictionary also defines incitement as follows, and I quote: the act of encouraging someone to do or to feel something unpleasant or violent, unquote. Drawing from the above definitions, the incitements involve provoking or instigating people to do an unlawful act and in their instant terrorist acts. The prosecution has led evidence showing that the defendants made broadcasts inciting public to take up arms against the security personnel in Nigeria to kill them and their family members. The broadcast of 24th day of October 2020, as contained in the IPOB, the defendants said, and I quote, Radio Biafra is now in the hands of the enemy of our freedom. I don't know how much they paid for it, but I know that Britain spent over 4.8 billion a few days ago to suppress what is happening. That is what they have done. I told you a while back that Britain was now in charge of what is happening in the zoo, and you thought that I was joking. They have now come with their clamp down, but they are now going. They are not going to succeed. Radio Biafra belongs to us, but why is it not playing out our program right now? Unquote. I am telling you, you people, to go to the bush. Whenever you see a military convoy, you attack them. Whenever you see a police convoy, attack them. They are human beings and they also bleed. Any person with a police uniform or any army in any army uniform is an enemy of the people, unquote. Around 57 minutes to this video mark, the defendant stated, and I quote, they came to Tinubu. It is surprised that after British High Commissioner came to Tinubu, they opened fire on protesters in Lagos. You should know, you should not by chalk that the woman is a devil, a big, big devil. She too will go, will get a comeuppance, unquote. The defendant was referring to Katrina Lee, the British High Commissioner at that time. The defendant also said, from what will happen in Aba between today and tomorrow, we tell you how serious we are. Every police officer with uniform, once you come out from your house with police uniform, you are dead man walking. Callers were calling in from places like Aba, like toll gates and other parts of Lagos, Ibadan, Abuja, Jos, Abia State, even one Jacob called from Nasarawa State. And the defendants kept giving orders for these callers and other listeners to kill every police and soldier. The defendant even told the people how to build an improvised bomb. He asked them to go to a filling station to get and put a rag in it. Then they should set the rag ablaze and hold it at soldiers. He responded to a caller call from Abuja. In that same broadcast of 20th October 2021, the defendant, while inciting his listener to attack the relative of security personnel, stated, and I quote, that every commander they have given his name, fields, find his children. I want to get him in trouble. When they take me to court and ask why I said such thing, I will tell them why. Find the commander. His name is Ifu Umata. Find his children. Find his children. the commander of those on the ground, find their children. Very, very important. Find their children. Unquote. If defendants went for that, and I quote, start attacking the police, take their guns, use them against them, manufacture motor tours, cocktail, manufacture bombs to bomb them. Unquote. The defendant asked about 2 hours, 44 minutes, 35-second mark, while concurring with a caller who informed him of the intention of him, other IPOB members, to burn down the Ezima police station, stated, not only one, I want every police station in Aba to be destroyed, completely, destroyed, and burn them down. It is an order destroying them completely. Anybody who sees them with police uniform, kill this person. Nigeria wants anarchy. We will give them anarchy. Unquote. In another broadcast, the defendant, while responding to the caller, stated this: you people must devise strategy to defeat the army. There are some guns in Edo State right now, as we speak. Use those guns to kill 1 or 2 of their army officers. Take their guns and begin to kill other people as well, because they cannot sustain this protest for 3 weeks. There are guns in the Edo State already. Kill the army whenever you see them. Take their guns and kill them. Unquote. The incitement of the defendant for the public to kill security personnel is quite clear from his bureaucracy. Not only incitement to kill security officers. The defendant even went as far as inciting the public to destroy all properties of federal government during the NSAS protest of 20th October 2020. The defendant, in another live video dated 20th October 2020, the defendant, while responding to calls from his foot soldier during the NSAS protest, stated, and I quote, if you leave the Janjaweed and their agents the way they operate, if you leave them, believe you believe me, you will suffer. That very hotel must be brought down. I did not say set ablaze. It must be demolished as an example to the rest. If you have not dealt with Tinubu in Lagos, the other will not learn their lesson. Tinubu is an evil man. The hotel referred here to is Oriental Hotel in Lagos, which defendants alleged belong to Tinubu. While responding to a caller, the defendant urged his callers to ambush the security forces during the protest and cut them off. He said, and I quote, go to the bush. You need to cut them off from the back, ambush them, take their guns from them and kill them. They are animals and not human beings. They may be wearing uniform like police or soldier, but they are animals. Disarm them and kill them. If you allow them to escape, your life is over. And I want Lagos Airport to be on flame. Breach the perimeter fence and burn down the Lagos Airport. If you have double barrel or pistol, go to the airport and burn it down. Set Muritala Mohammed Airport on fire. Set it ablaze right now. You are dealing with animals. Fulani Janjaweed, they do not reason. It is important to state that the said hotels and Muritala Mohammed Airport and other property in Lagos, they are not in the north, where it seems to hate with faction. Even his own fellow Igbo people have property in Lagos, which will be said to be agitation for self-determination. The threats and destruction which follow were corroborated in Exhibit PWD2, which is a pictorial pictures of the assessment of damage done to the Nigerian police alone in the state of southern states. So many of these police stations and even police officers were killed as a result of the incitement by the defendant. Also, Exhibit PWD-2A, which is a compilation of death reports and certificate of death of security officers in the report. The number of police officers who were killed was given as 128. Military officers were 37. Other security officers are 10. Number of police stations attacked were 164. INEC facilities destroyed were 9 in number. This clearly shows the extent of damage caused by the defendant through his inciting statements. Another caller called into the program informing the defendant that he was at Oshodi Apapa Expressway and that they are killing them. The defendant, annoyed by this information, stated, and I quote, "How many police did you kill? I don't want to hear that. They are killing you. How many did you kill?" The caller then responded that they have bombed the Orile police stations and Ilasa police station. The defendant then told the caller not to wave the green, white, green flag of Nigeria, but a blood-stained flag with the color green, white, red. He further responded to another caller by saying, "What I want them to do is to set ablaze the United building along Marina on fire. Every federal government property in Lagos should be burnt. That is what is going to be signal to the world that people have had enough. I want every federal government building in Lagos to be on fire. Every federal government vehicle or anything belonging to federal government, burn it. Go to the Muritale Mwale Airport, burn it. How many soldiers do they have? Manufacture your own weapons and ambush." The result of this incitement is the killing of several military officers, police officers, DSS officers. The incitement also led to the destruction of several police stations in Lagos across the southern states of Nigeria. According to PW5, he led a team of officers to investigate the destructions and killing of the security personnel that occurred during the EndSARS protest of 20th October 2020, as contained in Exhibit PWD2 and Exhibit PWD2A. The results were quite alarming. The court is mindful not to attribute all the happening during the EndSARS protest on the defendant. However, there is no doubt that the incitement by the defendant contributed likely to the killing of security operatives, as well as destruction of public properties. The defendant incited people to destroy property such as the Lassa police station, other police stations, and properties of the government. The evidence before this court shows that the said properties were actually destroyed, such as the Lassa police station, the High Court of Lagos in Igbosere, as well as BRT buses belonging to Lagos State government in Oyinbo. PW2 also testified that military couples were killed by those incited by the defendant in Olu in Imo State. In addition, PW4 stated that his driver and one of his tactical officers were killed as a result of the incitement. The action of the defendants were clear, as it was aimed to cause anarchy by killing security operatives in Nigeria, which would in turn lead to breakdown of law and order. The defendant had an evil intention to wreak havoc on the people and government of Nigeria. All these actions consistent with agitation for self-determination. The answer to this is in negative. His violent outbursts as instigations of the public to attack and kill security officers. Nigeria, without provocation, was downright barbaric and without any conscience whatsoever. The defendant did not feel any concern for the family of the officers who were slain He turned himself to a tyrant who could take life anytime he pleased. Such person cannot be allowed to remain in society of sane minds. An investigation to kill other woman was incomprehensible, and this court hereby condemned it. But I must say that the evidence extracted is minute compared to the avalanche of. I must say that evidence extracted in this judgment is minute and very small to the avalanche of evidence and broadcast before this court by the defendant. The defendant made extremely threatening statements, incited people to violence. The prosecution has successfully discharged his burden of proving counts 5, 4, and 5 beyond reasonable doubt. Consequently, the defendant is hereby convicted of the said counts 4 and 5. Now count 6. For count 6, the defendant is charged with the offence of making a broadcast receipt terrorism against the Federal Republic of Nigeria and the people of Nigeria, in which he is directed members of the indigenous peoples of Biafra, a proscribed organization, to manufacture bombs, thereby committing an offence punishable under Section 1(2)(f) of the Terrorism Prevention Amendment Act 2013. Section 1(2)(f) of the Terrorism Prevention Act 2013 provides a person or body corporate who knowingly in or outside Nigeria directly or indirectly, willingly assists, facilitates, organizes, or directs the activities of person or organization engaged in any act of terrorism. The ingredients of the offence expected to be established are: 1. The defendant must be a person or body corporate. 2. The defendant must have assisted, facilitated, organized, or directed the activities of person or organization engaged in terrorist activities. 3. The defendant must have willingly assisted, facilitated, organized, or directed the activities of persons or organizations engaged in terrorist acts. The defendants here have been established to be a woman. As to the second and third ingredient, the prosecution has led evidence to show that the defendant has directed members of the terrorist organization to build bombs, other explosives in order to attack security operatives. Indeed, in furtherance of his terrorist actions and following the incitement of persons to kill defendant security operative, the defendant also directed his members to build explosive devices, particularly motor coating. At about 1 hour 30 minutes 36 seconds of the broadcast of 20th October 2020, as contained in the PWW, the defendant, while responding to a caller about ENSA's protest, stated, and I quote, "Now, this night, I want graduates to go to work, graduates of chemical engineering, those who were born as engineers, manufacture any ordinance you can, because they are coming to kill you anyway, regardless of what you do. Go and manufacture any ordinance. I am calling on the youth in the Middle Belt, and I want any bridge that they can use to reinforce to be destroyed. They are going to come from the Middle Belt. This night, we have engineers everywhere, people who are intelligent. Go back now and give us your own version of motor coating. We must destroy them before they destroy us. Every youth tonight, anybody with a police uniform, anywhere, especially in Aba, in Lagos, once you have police uniform or any army uniform, that person is your enemy. Attack them, because if you don't, they will kill you. If you are a graduate of physics or chemistry, no sleep for you tonight. Go go and manufacture something to destroy the police and every army position starting from this night, unquote. During the said broadcast, while responding to a caller named Jacob from Nasarawa State, the defendant even told the people how to build an improvised bomb. He asked them to go to a filling station to get fuel in a bottle, put a rag in it, that then they should set the rag aflame and hot it at a soldier. Molotov cocktail, according to Wikipedia.com, that I accessed at 1 a.m. on 20th November 2025 is a hand-drawn incendiary weapon consisting of a fragile container filled with flammable substances, equipped with a fuse. In use, the fuse attached to the container is lit and the weapon is thrown, scattering on impact. Unquote. The online Britannica dictionary defines Molotov cocktails as a crude bomb, typically consisting of bottle filled with inflammable liquids and a wick that is ignited before throwing. Unquote. Applying the above definition, the directive of the defendant to members of the group to build improvised bombs such as Molotov cocktail is indeed a terrorist act. Molotov cocktail is capable of causing explosions, damage like any other bomb, which aim is to cause destruction. This directive, like other directive, is a manifestation of anarchy-minded of the defendant, which he sets out to express through his Biafra radio, which he claimed to be the founder and director. The defendant, through the radio Biafra platform, carried out so many terrorist attacks which led to the destruction of lives and property in Nigeria. The defendant is not only confirmed to local terrorists, but I hold without hesitation that he is an international terrorist, flowing from his threat to attack British High Commission and American Embassy, as well as his incitements against the British High Commissioner to Nigeria at the time, Catherine James, a known woman of peace. In a broadcast of 21st October 2020, the defendant stated thus, and I quote, "Radio Biafra is now in the hands of the enemy of our freedom. I don't know how much they paid for it, but I know that Britain spent about 4.8 billion a few days ago to support what is happening. That is what they have done. I told you a while back that Britain was now in charge of what is happening in the zoo, and you thought that it was a joke. They have now come with their clampdown but they are not going to succeed. Radio Biafra belongs to us, but why is it not playing our program right now? Unquote. The defendant also stated, I am telling you people to go to the bush. Wherever you see a military convoy, you attack them. Mark into that video. The defendant directed his threat at Catherine James, the British High Commissioner. He stated, and I quote, "Demon, a big demon, she's too, we go come repentance." Around 1 hour, 8 minutes, 35 seconds mark, the defendant also stated, and I quote, the same thing that British did to Biafra in what they are doing to us now, media blackout. Do you want the world to report this issue? Take over the British High Commission. That is all. Take over the consulate in Lagos. Take over the one in Abuja. Every newspaper in the world will report it in the morning. If you march on the British High Commission in the morning, front pages in the world will carry it, and the world will ask why is British Commission in Abuja and Lagos under occupation by Nigerian youth. Then it is over. I'm giving you a master strategy of how you should be done. In a formation of 3 lines, there is something I want you to do. I'm announcing it on air so you understand. People should go to every weather shop around you. You know those who build bulletproof door. I don't care how much it costs. We will pay. Everybody who is a welder, who builds bulletproof, people should take those doors and put nails in front of them and stand in front of protesters so that bullets cannot go through. Push the door, get the weapon, and deal with them. When you are marching to the British High Commission tomorrow, form 3 lines. They will have the army surrounding them. They will send a cable to London that British High Commission in Lagos is under attack. They will be forced to release it. Then the whole world will know that a revolution is going on. Without that, you cannot succeed. Even recently, in this courtroom, on the 7th day of November 2025, when the matter came up before this court, the court wondered the kind of malice and hatred which the defendant had for Britain. I will produce, say, part of the proceedings of that day hereunto. Defendants, he says, there are issues at play which my Lord has not able to overcome, which even the prosecution has not even attempted to overcome. My Lord, are you asking me to go into the doors to defend myself on a non-existing law? If you can state that for the record, my Lord, I will be most grateful that you are going to try me or ask me to enter my defense where no law exists. Because if that is the position, my Lord, that means that the outcome of very trial is predetermined. A man of my station and caliber cannot be tried without anybody's law. It is impossible, my Lord. I will tell you why. This was the case. This very case is bigger than this court. The case of mine started in 1957 when some brave men and women in this very country dared to ask the British to leave. The funniest thing is that all of them that organized that very effort, they all went to jail and were killed. Of course, I'm learning this now. Then ask the British to leave. Defendants. Yes, in 1957, Dr. Anthony Nao moved a motion at the House in Lagos, asking the white men to go and leave us alone. From that day, trouble started. Even before then, the like of Abad Macaulay was jailed, honorable men that fought for the indignity of the black race because they want me convicted. They told me so. Absolutely, my God. Absolutely, 100%. They told me. They said, I will come to court to see, to hear your case. When you take your plea, when prosecution opens, then their case, when prosecution opens their case, when you start your cross-examination, when they refuse your no case submission, I am telling you what happened a year and a half ago when you file your no case submission and it's rejected. You will not go into trial. You will be there during the verdict. You will be there during conviction. The court now responded. Let me just clarify this. It is also on record. You said that the British said that 1 year and a half ago that I was not the one presiding here. I want to say this, that I know my brother too, that was assassinated. Ascertain it will not get into that level of having anything to do, anything, because the way you are putting it. I want to say this. I do not have any relationship with the British. I have come here to do justice. I reiterate. Can you commence your defense so that if you commence to them as a result of the protest? The defendant at about 2 hours, 24 minutes, 50 seconds, mark of the video of 24th day of October 2020 broadcast in Exhibit PWW stated, American embassy is shut down. Why won't they shut down? People are protesting. This statement regarding the embassy of United States of America is quite loaded. The statement will mean several things, none which are palatable or peaceful. What exactly does the defendant mean by the American embassy is shut down? Was he trying to attack the embassy if it has not shut down as a result of protest, or incite others to do same as he did in British embassy? The inference to be drawn from the statement is that the defendant meant to do harm to the embassy of the United States by attacking or invading the embassy. Under international law, the premises of an embassy or high commission of a foreign nation is deemed invaluable. That means that even though the land belongs to a host country, it cannot invade such premises. See Article 22 of Vienna Convention on Diplomatic Relationship, or Article 22 of Vienna Convention on Diplomatic Relations, 1961. It provides thus: the premises of missions shall be inviolable. The agents of the receiving state may not enter them, except with the consent of the head of the mission. 2. The receiving state is under special duty to take all appropriate steps to protect the premises of the mission against any intrusion or damage, and to prevent any disturbance of the peace of the mission or impairment of its dignity. 3. The premises of the mission, their furnishings and other properties thereon, and the means of transport of the mission shall be immune from search, requisitions, attachment, or execution on courts. Thus, from their oath, it can be said that the defendant incited for people to invade British High Commission and is threat against British High Commissioner Catherine Leon and American Embassy is an act of international terrorism. This is the purpose of Section 3 of the Terrorism Prevention Amendment Act 2013, which provides, and I quote, any person who intentionally murder, kidnap, commit other attacks on persons or liberty of an international protected person, B, carries out violent attack on official premises, private accommodation, or means of transport of an international protected person in a manner likely to endanger his person or liberty. C, threatening to commit any such attack, commit an offense and is liable on conviction to life imprisonment. The High Commissioner is an international protected person, being the representative of the British government in Nigeria as well as other staff of High Commission and Embassy of the United States of America, leaving the defendant to continue his terrorist activity who have led to an international incident involving Nigeria and other foreign nations who are good partners with Nigeria. The question to ask again is whether bombing or attacking embassies of high commissions constitutes an actor consistent with agitation for self-determination. Again, the answer is no. All this acts goes to show that the criminal tendency of the defendant as well as show concrete proof of his terrorist acts. Therefore, I hold without hesitation that the prosecution has successfully established counsels against the defendant. Consequently, he is hereby convicted of counsels of the charge. With respect to counsel of the charge, the defendant is charged with importing into Nigeria and keeping in Ubuluzo in Ihiala, local government of Anambra State, within the jurisdiction of this honorable court, a radio transmitter items which he declared as used household items, thereby committing an offence contrary to Section 47(2)(a) of Custom and Excise Management Act Cap C45, Laws of the Federation of Nigeria 2004. The dispute as to which law provides for the offence in Count 7 has been conclusively decided by the Supreme Court in case of Federal Republic of Nigeria versus Kanu Supra, where my Lord M.L. Garba, KSC, while reading the lead judgment held, and I quote, a calm reading of the details of the facts stated as constituting the offence mentioned or named therein would clearly and undoubtedly reveal that it deals with the offence punishable under the provision of Section 47(2)(a) of the Custom, Excise and Management Act, Cap C45, Laws of Federation of Nigeria 2004, which provides as follows: 47(2). If a person A imports or causes to be imported any goods concealed in a container holding goods of different descriptions, or he shall be sentenced to imprisonment for 5 years without the option of fine. It follows in the above circumstances that the mention of the Criminal Code Act as in Chapter C45 or Chapter C45 in Laws of Federation of Nigeria 2004 is a mere mistake in place of correct law. The Customs and Excise Management Act, under which the facts alleged to constitute an offence in Count 15, is punished and punishable. The offence in Count 15 is consequently recognizable and grounded in an extant existing law in Nigeria in which it was defined and described, unquote. Thus, the court will follow the decision of the Supreme Court and decide Count 7 based on Section 47 of the Custom and Excise Management Act. The ingredients of the offence are: the defendant must have imported or caused to be imported goods concealed in a container. 2. The imported concealed goods must have been of a different descriptions. The evidence led by the prosecution through PW4 is that the defendant imported into Nigeria a radio transmitter known as Tram 5 550L concealed in container which contain used household items which he described as such. PW4 stated that indeed the Department of State Service had tracked the transmitter of Radio Biafra to a compound in Umudu Dino in Ihiala, local government of Anambra State, belonging to one Benjamin Madubulu. The officer secured a search warrant as the PWT and proceeded to the compound where they recovered the container. Prior to going to the scene, PW4 testified that he watched a video of the defendant inspecting the container and the transmitter with Benjamin Modubugu. The court visited where the container was kept in the custody of the DSS and same was admitted in evidence in the presence of the defendant as exhibit PWY, and he did not object to same. The container itself contains several household items which appear to be covered for the transmitter concealed in it. The prosecution has led evidence to show that the transmitter was smuggled into the country without sale being declared to customs. That the cover of the household item was used to disguise its true content. The surrounding facts also show that the purpose for which the defendant intended to use the transmitter was to broadcast program on Radio Biafra, and this makes it conceal the transmitter. This is also not. There is also no evidence that Radio Biafra is registered with Nigeria Broadcasting. As a consequence of pressing his case on the prosecution, did not call any witness to report the evidence of the prosecution, neither did he leave any evidence to counter the evidence of the prosecution. There is no evidence before this court stating the transmitter was lawfully imported into Nigeria. The defendant has the duty to present evidence and failed to report the allegation made against him, but he failed and deliberately refused to do so. The court is therefore bound to believe the evidence of the prosecution. Consequently, the court hereby convicts the defendant of count 7 of the charge. I must say here that defendants have always claimed to be a freedom fighter. He is only seeking justice for his people. Indeed, this is known in law as the right to self-determination. The right to self-determination is a political right recognized in several international instruments. Article 1 of the International Convention on Civil and Political Rights, 1966, provides, and I quote, all people have the right of self-determination. By virtue of that right, they freely determine their political status and freely pursue their economic, social, and cultural developments. Unquote. The right to self-determination also entails the right of a group of people to form their political entity or their own government. Article 20 of the African Charter on Human People's Rights provides, and I quote, all people shall have the right to existence. They shall have the unquestionable and inalienable right to self-determination. They shall freely determine their political status and shall pursue their economic and social development according to the policy they have freely chosen. 2. Colonized or oppressed people shall have the right to free themselves from the bond of domination by resorting to any means recognized by the international community. 3. All people shall have the right to the assistance of the state parties to the present charter in their liberation struggle against foreign domination, be it political, economic, or cultural. Unquote. Nigeria has domesticated the African Charter, which is known as the African Charter on Human and People's Rights, Ratification and Enforcement Rights, which means the provision of the Charter are enforceable in Nigeria, provided they do not conflict with the clear provision of the Constitution of the Federal Republic of Nigeria 1999 as amended. Section 2(1) of the Constitution of the Federal Republic of Nigeria 1999 as amended makes it clear that Nigeria is an indivisible state, which means there is no room for division. The said section provides, and I quote, Nigeria is one indivisible, indissoluble sovereign state to be known by the name Federal Republic of Nigeria, unquote. This means that anyone agitating for a breakup of the Federation of Nigeria is going against the Constitution. However, any person agitating for self-determination can do so through the National Assembly seeking for amendments of the Constitution regarding the indivisibility of Nigeria and to reflect the recognition of the agitating states. It is after this that the procedure can be said to be completed, but not excluding a referendum. Any self-determination not done in accordance with the Constitution and laws of the country will be illegal. The defendant is not only agitating for secession of the states of the Southeast, South, and some Middle Belt states. He is doing so using terrorism as a weapon. Terrorism has become a monster in the world today, and several groups have continued to use this weapon to form separate governments. In Nigeria, groups like Boko Haram, Lakurawa, IPOB have in recent years troubled Nigeria with terrorist activities. This terror group, by their activities, has denied innocent people the enjoyment of their fundamental rights. The action of the defendant and his terrorist organization have led to the bloodshed of innocent citizens, as well as security personnel who were going about their legitimate duty. His incitement through the broadcast on Radio Biafra as well as the social media platform of the group has led to the destruction of lives and property, as well as affect the daily life of his people of Southeast. The defendant did not only threaten the government of Nigeria, but his own people. This is seen in a broadcast while addressing the death of one of the commanders of IPOB, named Ikozo. The defendant on 25th day of April 2021 made a broadcast where he stated, and I quote, Ikozo was not killed on the battlefield, but was killed in his village in the middle of the night. Not on the battlefield, because of the battlefield, no army or police can defeat him. Ever since Eastern Security told me that their life have not improved since it was launched. Around 21 minutes, March, the defendant stated, vengeance is a monster of appetite, forever blood-tasty, never filled. Ikozo is in heaven. He is going to be revenged, and by God, he will be revenged. All those who had hands in Ikozo death are all dead. People working, all of them. One, special with the Oba of Guinea is very that he said Ikozo is more than an Oba. Thank you. That upon the arrest of one of the IPOB commander named as Onye Army, he informed them that they were only to get 30 heads of women out of 2,000 heads of as ordered by the defendant. This court is aware that the said Onye Army was not caught as a witness in this case, and this may affect the probative value of his evidence. However, the evidence being used, this evidence is being used as corroboration to the statement made by the defendant himself, admitted by the statement of, and is admitted as a defendant for that purpose. Corroboration refers to supporting or additional piece of evidence that supports another evidence. See Ogunbayo and the state citation supply, where the Supreme Court held, and I quote, corroboration having been held not to be a technical term of all, means no more than evidence tending to confirm, support, and strengthen other evidence sought to be corroborated. This evidence is to corroborate the evidence, the statements of the defendants. I must say here that the prosecution witnesses were consistent and calm in the giving of the evidence. Their calm demeanor, despite provocative questions under cross-examination, shows that them to be witness of truth. I carefully observed them, and the only conclusion to reach is that they are witness of truth. And this court readily believed them. The defendant, on the other side, from his attitude in court, was truly very cocky, arrogant. He even stated that no court can convict him. This is a direct affront on the power of the court, which this court will not take for granted, but will do justice. It is interesting to note that the defendant, who claimed to be a freedom fighter, has even caused more harm to his own people, who are predominantly Christian faiths. Can this be said to be agitation for self-determination? Not at all. Agitation for self-determination cannot be to the detriment or to be detrimental to people who are supposed to be beneficiary of that self-determination. The usual sits at home order primarily affects his own people of the South-East. The killing of people who disobey the order are his own people. Ordering of closure of churches and schools as well as markets also affects his own people. They are unable to trade, go to school, farm, even worship on such days. The threat of violence and death have prevented these people from going about their legitimate businesses. Are these acts of defendants consistent with the agitation for self-determination? The answer is in the negative once again. The defendant was not elected by anybody, also cannot dictate for the people of Southeast, especially through intimidation and threat of violence. He is a terrorist. He must be treated as such. In final analysis, the prosecution has successfully established the 7-count charge against the defendant beyond reasonable doubt. Consequently, he is convicted on all the 7 counts. By the time the next just 30 minutes I go to the chambers, anybody is free to come and get a certified true copy of the judgment.
As the court pleases,
When I get to the chambers, the next 30 minutes it will be signed.
Thank you, my lord. May I invite your lordship's attention to the title of this case. It is Federal Republic of Nigeria versus Nnamdi Kanu.
Commissar?
Look, the people, 200 million people of Federal Republic of Nigeria have brought Nnamdi Kanu before this court for acts of terrorism. And my lord, in the last few weeks or last few days, Nigeria has been a season of victims of victims of terrorism. But my lord, this afternoon, this honorable court delivered its judgment in which the convict Nnamdi Kanu was found guilty and convicted of offences under Terrorism Prevention and Prohibition Act. He has accordingly been convicted and it is now to be sentenced. And Lord, the prosecutor has a duty to invite your lordship's attention to a few points that regard your lordship in the sentencing. My lord, this court has again affirmed the long-standing principle that whenever Nigeria as a nation then the country, guided by the wisdom, courage, and integrity of judges who serve within that arm of government. Terrorism, my Lord, remains one of the greatest threats to humanity. It is among the most devastating of atrocities in human history. As the leader of the proscribed indigenous people of Biafra, the convict, through his broadcasts on Radio Biafra and through the group Armed Wing, the Eastern Security Network in Nigeria, and took active steps to destabilize the country. By the conviction of Nnamdi Kanu for acts of terrorism, it is clear that justice has been served to the thousands of innocent Nigerians who lost their lives as a result of the inciting broadcast and violent activities of the Eastern Security Network. The blood of those who have died cries to heaven, and God in his mercy has given them justice. Justice has honored their cry. The families of more than 75 security officers who were murdered in the service of their fatherland will now find some comfort in this conviction. Those whose relatives were brutally killed and buried with e-counsel of the order of the convict here have not died in vain, because justice has been done. And Lord, the record before this court are replete with the losses suffered by citizens of Nigeria residing in the interstates of the Federation. Citizens who, through no fault of their own, were forced to live in fear, had their businesses destroyed, and were reduced to paupers as a result of stay at home orders issued by the convicts and violently enforced by the commanders of the ESN. Justice has today set them free from oppression and economic strangulation caused by the terrorist activities of the convict. The convict now knows that the law is greater than any individual. Therefore, justice has been done to him too. And that Nigeria has both the power and the capacity to punish anyone who does deliberate, reckless act of terrorism, seeks to divide the country by attempting to create the so-called Republic of Biafra by force out of the Federal Republic of Nigeria. My Lord, consequent upon the conviction, as nothing further remains but the lawful imposition of sentence. The punishment prescribed for the offences in counts 1, 2, 5, and 6 is death penalty. Pursuant to Section 1(2)(h) of the Terrorism Prevention Amendment Act 2013, my Lord, with all sense of humility, I say, sir, as a prosecutor, that this court has no discretion in that regard, and that the only sentence that your Lordship will impose for counts 1, 2, 4, 5, and 6 is death sentence. This court has the power to do so, and with respect must do so. The language of the Act is clear, and the court is urged to apply it strictly without deviation. For the offense under count 3, relating to membership of IPOB, a proscribed terrorist organization, its punishment is imprisonment for a term of not less than 20 years, in accordance with Section 16(3) of the Terrorism Prevention Amendment Act 2013. We urge your Lordship in accordance with death sentence, to also pronounce and impose the sentence as prescribed by law. I won't find him guilty and convicted. For the offense under count 7, the punishment is 5 years imprisonment without the option of a fine, pursuant to section 46 and 47 of the Custom and Excise Management Act, Cap C for the purpose of federation. In sentencing, this honorable court is obliged to consider the nature and gravity of the acts of terrorism committed by the convict. Against the acts of terrorism were against innocent Nigerians who reside in the southeastern states. It is also a terrorism act against Nigeria, whereby nobody felt safe and secure in Nigeria having regards to the activities of IPOB and ESN. The court is also note that the country has shown neither remorse nor penitence for the innocent Nigerians who died as a result of his directives and incitement. He has demonstrated no respect for the administration of justice. His conduct, even within the court, has been marked by arrogance and a heart far removed from humility. When he was going out, he looked at me and said, God will bless me. He won't say God will punish me. He said, God will bless me. And I say, amen. Because I'm a blessed man. It is not he, the convict, who can now put a curse on me. He cannot do that. So in any event, my Lord, I'm not being personal, but I want to assure you that somebody in that position ought to show some penitence, ought to show some remorse, ought to throw away arrogance and self-serving attitude. The court is further urged to take judicial notice of the fact that the convict established radio transfer, a broadcasting platform operating on several digital channels, including mobile radio, Twitter, YouTube, Facebook, WhatsApp, blogs, and Instagram. It is a station with global reach. Evidence before the court, my Lord, shows that when the convict was arrested on 15 October 2015 at the Tulip Hotel in Lagos, he was found in possession of broadcasting equipment. The conduct of the defendant through online publications, live broadcasts, and social media communications constitute acts of incitement, encouragement, and provocation of terrorism as defined under the Act. In view of the prosecution, my Lord, that without the instrumentality of the internet and social media platforms, the magnitude of destruction, division, and human losses recorded in the southeastern state of Nigeria, including Lagos, will not have reached the level it attained. The digital platform becomes tools in the hand of the convict, tools of radicalism, ethnic hostility, and incitement to terror. Their amplified resulted in a coordinated transnational militarism or militarization of violence and destructions of public property across several states of Nigeria. The court has both the power and the duty to restrict further access to digital media through which the offences were committed by making orders that prevent the commission of similar or related offences, including forfeiture, confiscation, or restrictions of the means used to commit the act of terrorism. As a form of preventive control, the prosecution pressed this honorable court to impose restrictions on the convict's access to digital devices, online accounts, or internet facilities. In other words, my Lord, anywhere he may be kept until his execution in obedience to the sentencing, if he has access to these devices, and they are cheap and easy and available everywhere in Nigeria, there will continue to be broadcast. Maybe he will claim he was not the one. At the moment, if you open to YouTube, you see a lot of rascals talking about the proceedings of his court, trying to twist and mislead and mislead the people with what happened in court. So we're asking that your lordship should restrict him from having access to these devices. This Honorable Court, my Lord, has the sacred power to prevent convicts from further committing offences by making orders for the forfeiture, confiscation, and restriction by any means used for communication. We therefore pray that the courts to order the forfeiture of all the broadcasting equipment, digital devices, and all the electronic materials seized from the convict and currently in the custody of the Department of State Security State Service. In particular, the radio transmitter Trans-50L, unlawfully imported into the country, should be forfeited to the federal government of Nigeria. My Lord, we want to say, sir, with all respect, that it might be argued that access within the constitutional rights, but it's not absolute. So therefore, sir, if your lordship want to order this restriction, your lordship may say, may give him the right to acquire any, but with the permission, with the authority of National Security Advisor and the Controller General of the correctional facility that he may be put. Therefore, my Lord, it's not an absolute or free right for him to begin to acquire those digital devices that may encourage him to reenact or to begin to commit the same or similar offense under his right to freedom of speech. So we are saying, my Lord, that your lordship should restrict it. My Lord, considering that the company has to be in a custodial facility, we are asking your lordship to direct that for the safety of the convict, for his safety, for his security, and for the protection of his life until your sentence or is executed, I respectfully, sir, as prosecutor, plead with your lordship to direct that he be kept in the safest custodial center anywhere in Nigeria, because his safety is very important. Your lordship need to take judicial notice of what happened when Simon Ekpa was sentenced in Finland. There were lots of talks and talks. The convict has enemies. He has friends. But no one can say the volume or the number of his enemies who may want to eliminate him. So we are asking that your lordship order the government of the Federal Republic of Nigeria to keep him in the safest custodial center anywhere in Nigeria. You know, and if I may say with all sincerity, I am not too sure that Kuje, where there have been jailbreaks, will be the ideal place. So I'm urging your lordship with all sense of responsibility to preserve his life until he answers his sentence. So I thank your lordship and I pray that the incidents of terrorism will cease from Nigeria, from north to east, to northwest, to north central, and as we see, may God spare Nigeria of disintegration. I want to thank you. I want to appreciate you on behalf of my colleague, Adegboyega Awomolo, as right sider. We are grateful to your worship, a well-researched, a well-reasoned, and a courageous judgment. Thank you, my Lord. There is no doubt that the convict has waived his right to be present through his unruly attitude, his habitual unruly attitude to be in court when the judgment was read. But we must still give him opportunity to hear one or two things from him, but not personal, through his person. Since his consultant is here, and the offense has to do with death sentence, I will call his consultant, that was his lawyer before he converted him to consultant, if he has any allocutors to make on his behalf. Mr. Jimako, do you have any allocutors to make on his behalf?
My Lord, being an officer in this temple of justice and not being properly dressed and not being his counsel of record, I will yield this very task to Honorable Obinna Agocha, who is better qualified than me being the member of House of Representatives who represents Nnamdi Kanu.
It's okay. Honorable, let me have your full name and restrict yourself to allocutors. Allocutors is what will mitigate the sentence. Is our brother. Let us hear you. You tell us your name. You can't, because of your ruling behavior, deprive him of allocutors. Can I hear from you?
Thank you, my Lord. My name is Right Honorable Obi Agocha. I represent the good people of Iguano, Umaya North, and Umaya South Federal Constituency in the 10th National Assembly. My Lord, I am the direct representative of Nnamdi Kanu. That's why you see me here almost every time, showing presence and also showing solidarity with him. The matter has come to a closure for now. I'm not his lawyer. I wouldn't know whether they will seek appeal. But for now, the Lord, he is my brother, he is my friend. I went to school with him. We attended primary and secondary school together, though he was my junior. But it is my responsibility and obligation as a member of the National Assembly to represent him as well. The Lord, I plead for mercy, plead for clemency, and I appeal for peace and for stability of not just the Southeast, but as well as Nigeria. Like the prosecutor said, Nigeria is bleeding over the last few days, and we must bring some of these issues to bear and to understand how to find common solutions to our common problem of terrorism. I also wish to appeal to the prosecution team that it's been done to Nnamdi Kanu. There are other people out there also doing more worse than him.
Please,
Sorry, sir.
I ask for allocutor.
Yes, sir.
Please, don't
I apologize, sir. So I want the court to take judicial notice of that this trial has gone on for almost 10 years. Nnamdi Kanu is almost 56 or 57 years old now. He has been absent in his family life, his children, his community, his family. So I plead for the Lord to show mercy, to temper justice with mercy. And as we move forward, it shall be great for our country. Thank you very much for the opportunity. At the front of the court, I will come from the other side of the government. So thank you for giving me the opportunity to address the court. Thank you, sir.
Thank you. I will consider all this, and I will rise and come back by 10 minutes to 4. You may go and come back 10 minutes to 4 for the sentencing. I will rise and come back.
You have been watching live court judgment of the Nnamdi Kanu trial. We will continue with the reading of the judgment of Nnamdi Kanu's terrorism trial once the court is back from its recess. So far, Kanu has been found guilty of 8 charges, including threats, incitement, and terrorism. Some of the charges involve the possibility of the death penalty. Adegboyega Awomolo, speaking for the prosecution, has said justice has been done and has urged the court to impose the maximum sentence across several charges. That maximum is a death sentence. Also happening now is a place at the table town hall on gender-based violence. So let's now head over there as the conversations progress.
Community level, to engage them, to hear their stories. And we made a program out of it called Kigbajare. It was in Yoruba, so that we get the kernel of what the women had to say as women leaders. And I can just imagine if more radio stations and more TV stations did something like that, to mainstream, to tell stories, to go to the heartlands, you know, to engage with young girls and men and women, to hear what they have to say about SGBV. Because, and I say this because there are different narratives out there. I will center my engagement on male narratives. And it's not monolithic. It is a spectrum from defensiveness to all kinds of things. But I will stick to the defensiveness of men. When they hear cases, and I'm not demonizing men, I have wonderful men in my life, and I know the men are coming for their session, so I can already see that they're gathering strength to puncture what I have to say. But this is the thing. When many men hear cases of SGBV, they feel defensive. Not all men. And so they shift the conversation from a systemic one to an individual one. So this is not about protecting an individual man or the ego of an individual man. It is about having this conversation, moving it forward, seeing that it is not about an attack on men. And I need our men to chew on that. I find it strange that no matter the case of SGBV in Nigeria, men rarely feel outraged. I wonder why. I think as a media person, we should do more stories about men's reactions because, like it or not, we live in a patriarchal society. And we cannot do it alone as women. We have to have the men in this ring with us to fight this. You hear of Ochanya, a man and his son violates, you did the movie violates a schoolgirl. And Nigerian men are not outraged. You hear of different cases, and you just don't see men leading to say, no, this cannot go on. Each time you talk about this toxic masculinity, they're up in arms, forgetting that there are two sides to a coin. Talking about toxic masculinity does not mean that there is no positive masculinity. It's a call to those who live as positive masculines to get into the ring and look at how they can influence, because they're all we have celebrities. I'm talking too much, right?
You know, because they have celebrities, and we can begin to create programs. You ask for solutions as well. We can begin to create programs that will center on maybe podcasts even, that will bring in the men and, you know, center on particular cases and feel their reactions. We need to begin to get even more reactions from men within the news bulletin, the news hour. It shouldn't be so power relations regulated. You see, most times our news is masculine. I'll stop there.
Thank you for that. So in storytelling is where we're seeking for understanding, for empathy, and to change male perspectives is what you're going for. Male perspectives around sexual assault and gender-based violence. Very valuable point there. I'm going to let you speak next, and then once we've done that, we can then come back and sort of exchange a few more views and find maybe solutions.
No question for me?
Not a particular question, but, you know, for you to just tell us what you do and just speak to the conversation that we've been having around just narratives and what you